The International Court of Justice should make a general assessment of this situation so as to determine the legal implications resulting from it. In this regard, the Republic of Cuba believes that rather than an obvious apartheid regime situation prosecuted as a crime against humanity, this is indeed an act of low-intensity genocide that is perpetrated with systematic and effective cruelty. To qualify Israel's action merely as acts of apartheid would leave out the implicit intention to exterminate the Palestinian people, either in part or as an ethnic and religious group to whom the right to self-determination is denied. In case there was any doubt about the arguments that Cuba presented to the court in its brief, the current situation that is taking place in the eyes of all confirms the ongoing genocide. Innocent victims, girls, boys, women, civilians in general, numbers in the thousands. For the Genocide Convention to apply, the life of one single victim or the incitement, attempt, or conspiracy to commit such acts would be enough. The Convention Against Genocide also punishes the accomplices and instigators, those who veto decisions and prevent the international community and the United Nations from taking action, those who oppose an immediate ceasefire and the delivery of humanitarian aid, those who for years have supported each and every one of the policies and practices of Israel, the occupying power, which deny the existence of the Palestinian people and their rights. This agenda, to a large extent, has advanced in the course of time. We are convinced that this court should not wait for the complete extermination of an entire nation before ruling on the matter. That was the intention of the UN General Assembly in requesting the advisory opinion. The terrible situation currently facing the Palestinian people is a reminder of the urgency of a clear and consistent statement on the questions submitted to the consideration of the court. Israel, the occupying power, and its allies must take responsibility for the legal implications resulting from the sustained non-compliance with the international law. Consequently, the analysis of the international responsibility of Israel should go hand in hand with the responsibility of the United Nations and the member states that hinder its actions, creating by sustained and continued omission an international wrongful act that aggravates and worsens a clear situation of violation of international law in the Palestinian occupied territories. There should be a clear and unanimous ruling by the court that impartially and independently establishes the legal implications resulting from depriving the Palestinian peoples from their fundamental rights, including the right to life, freedom, and self-determination. Mr. President, members of the courts, related to the second part, added to the aforementioned international violations, there is the indolent attitudes of Israel, the occupying power, of ignoring the numerous resolutions and decisions adopted by the UN General Assembly, the Security Council, and the International Court of Justice. In this regard, and without intending to cover all issues, our brief to the court contains a report on the violations of the aforementioned provisions. In line with the foregoing and all other relevant opinions that may be contributed by other states, the main legal implication from this violation, resulting from this violation of international law, should be the declaration of the international legal responsibility of Israel, the occupying power, and its accomplices. All this based on the series of conventional and customary primary rules of international law that have been violated by Israel. Likewise, the aforesaid responsibilities and legal consequences must be established for Israel and its accomplices, in accordance with the secondary rules of state responsibility for internationally wrongful acts contained in the draft articles of the International Law Commission, as reflected in document A5610. It would be appropriate for the Court to provide in its advisory opinion that the international responsibility of Israel covers all illicit acts or omission of its state bodies, and those executed by persons or entities exercising powers of public authority, acting in the absence of official authorities or under the guidance or control of the occupying power. These secondary rules that govern the international responsibility of states clearly establishes the guidelines to determine the legal implication of the internationally wrongful act. This would motivate a strong ruling by the Court, indicating the immediate obligation of all states, in particular the occupying power, to comply with the conventional and customary norms flagrantly and systematically violated in the Palestinian territory, including the cessation and non-repetition and reparation for the damage caused to the Palestinian people referred to respectively in Articles 29, 30, and 31 of the draft articles on responsibility of states. All of the foregoing is without prejudice to the applicable provisions of treaty law. In addition, the International Court of Justice should separately address the international responsibility of other states for the aid and assistance they offer to Israel, including those that supply weapons. It is an undisputed fact that certain members of the organization violate the principles reflected in Article 2 of the Charter, not only by denying the sovereign equality and rights of the State of Palestine, but also by acting in bad faith in such a way that precludes any possibility for a negotiated solution to the conflict that, far from being resolved, has worsened over the last 70 years. In all these years, the United States has systematically and consistently overused its veto power to prevent any effective action by the Security Council and to ensure impunity to Israel. Just yesterday, the U.S. vetoed for the 48th time a Security Council resolution related to the Palestinian question. The International Court of Justice should emphasize the scope of Article 2.5 of the UN Charter, which states that all members shall refrain from giving assistance to any state against which the United Nations is taking preventive or enforcement action. This entails the obligation of all states to abide by the decisions adopted by the organization as a whole, particularly when the Security Council remains passive by the indolent attitude of one of its permanent members, the United States of America. And the United Nations General Assembly has continuously and categorically taken a stand on this question, supported by the International Court of Justice. Mr. President, members of the courts. To conclude, and based on the foregoing and especially taking into account the unbearable situation of the Palestinian people, the Honorable International Court of Justice should take a stand in the clearest, strongest, and most forceful legal terms in support of international law. The advisory opinion should establish the legal implications for Israel, other states, and the United Nations for the violation of the norms against the threat or use of force, equal rights and self-determination of people, as well as of the main international human rights instruments, the Geneva Convention on the Protection of Civilian Persons in Time of War, the Convention on the Prevention and Punishment of the Crime of Genocide, and the continued non-compliance with decisions of the UN General Assembly, Security Council, and the International Court of Justice. A special pronouncement would be merited by the issues related to the character and status of the Holy See of Jerusalem, Holy City of Jerusalem, in light of the continuous violation by Israel and the regrettable inaction of the United Nations, a direct result of the abusive and irresponsible exercise of the veto privilege in the Security Council. The Court should carefully think about the legal implications of these actions or omissions. We understand that once the Court has declared the existence of a situation of violation of international law, for example, the commission of a crime of genocide, war crime, or crime against humanity, there should be clear legal implications for all states that act in a way that ignores or undermines the decision or opinion of the Court. Actions or omissions that support violations of general international law should be held to be incompatible with the exercise of any international privilege. Honorable magistrates, it is up to the International Court of Justice to render the peace and justice that the Palestinian people deserve, without political double standards. That is the reason why the delegation of the Republic of Cuba respectfully requests the prompt issuance of an advisory opinion against the many years of genocidal impunity, clearly stating the international implications and responsibilities of those who, in one way or the other, contribute to the extermination of the Palestinian people. The international community requires a pronouncement that makes it clear to those responsible that today they may use their force against the innocent civilians, but this force will not be enough to spare them from justice. I thank you very much.
I thank the delegation of Cuba for its presentation. I invite the next participating delegation, Egypt, to address the court and call Ms. Jasmine Musa to the podium.
Mr. President, distinguished members of the Court, it is my great honour and privilege to appear on behalf of Egypt, of the Arab Republic of Egypt, in this advisory opinion of historical importance, in which the General Assembly is once again seeking the Court's guidance in respect of the question of Palestine. This comes against the backdrop of a 75-year history of displacement, dispossession, collective punishment, and daily, indiscriminate and systematic violence and human suffering of untold proportions. Mr. President, as we speak, Israel's brutal onslaught continues to rage in occupied Gaza, where 29,000 innocent civilians have been killed and almost 2.3 million people forcibly transferred and displaced in violation of international law. Israel is deliberately and wantonly creating conditions of life that are intended to make life in Gaza impossible, imposing siege and starvation, including by impeding humanitarian access and the distribution of relief through constant obstruction and bombardment. With the impending attack on Rafah, where 1.4 million people have sought refuge, Israel is continuing its policy of mass forcible expulsion of Palestinian civilians, all while the Security Council repeatedly fails to call for a ceasefire in callous disregard for Palestinian life. Simultaneously, Israel is continuing its illegal practices in the West Bank, scaling up attacks, access restrictions, punitive house demolitions, and supporting settler violence that has displaced entire communities. Increased settlement activity continues to erode the basis for a two-state solution, dimming prospects for a lasting peace in the region. These ongoing grave violations of international law by Israel, the occupying power, are part of a wider policy that seeks to dispossess the Palestinians of their land and assert Israeli sovereignty over it. This is manifestly illegal and renders the occupation as a whole unlawful. It is shocking that at this critical moment, some states would rather see this court abscond its responsibility as the principal judicial organ of the United Nations by declining to render this advisory opinion. What message does this send about these states' respect for international justice and the rule of law? Mr. President, I will focus my statement on 4 main points. Namely, number 1, the court's jurisdiction and competence, the legal framework for assessing Israel's prolonged and illegal occupation, which violates non-derogable principles of international law, the purported justifications of self-defense or military necessity, and finally, I will conclude on the legal consequences and a summary of Egypt's submissions. First, on the matter of jurisdiction and competence, the small number of states objecting to the court's exercise of jurisdiction have variously argued that the request is politically motivated, instrumentalizes the court, circumvents the consent of Israel, covers too vast a scope, or will prejudice the peace process and negotiations between the parties. Let me recall that the court has repeatedly and consistently rejected such arguments. In the Kosovo advisory opinion, the court did not concern itself with the motives which may have inspired the request or the political implications of its opinion. Since the General Assembly is duly authorized under Article 96(1) of the UN Charter and brought forth its request through a validly adopted resolution, the request, in the court's own words, in principle, should not be refused. In the nuclear weapons and Chagos advisory opinions, the court refused to second-guess the decision of the General Assembly, stating that it has the right to decide for itself on the usefulness of an opinion in light of its own needs. Distinguished members of the court, the General Assembly has turned to this august court with what is manifestly a legal question, seeking a legal answer that would indisputably assist in discharging its functions. Allow me to recall that this very court, in the Wall opinion, affirmed the UN's permanent responsibility for the question of Palestine until such time as it may be resolved in all its aspects in a satisfactory manner in accordance with international legitimacy. In the Wall opinion, the court found no merit in the proposition, echoed by some in these proceedings, that the ongoing negotiations constituted a compelling reason to decline its competence. It reached a similar conclusion in the nuclear weapons advisory opinion after noting that its opinion would have relevance for the continuing debate on the matter in the General Assembly and would present an additional element on the matter. Indeed, rather than prejudicing the peace process, the present advisory opinion serves not just as an additional element, but rather an essential one for the General Assembly to continue to carry out its role in relation to the Palestinian-Israeli conflict. This is absolutely critical given the complete absence of any real prospect for a peaceful solution. The Court could not possibly turn its back on this wealth of jurisprudence or disregard the many compelling reasons for it to honour the General Assembly's request. As summarised so aptly by the representative of Palestine, the Middle East region yearns for peace and stability, and a just, comprehensive and lasting resolution to the Palestinian-Israeli conflict, based on the principles of international law and the establishment of a viable Palestinian state on the pre-1967 lines, with East Jerusalem as its capital. The legal determination by the Court in the present advisory opinion is indispensable to guide the General Assembly and the international community to achieve this objective. Second, Mr. President, I turn to the question of the ongoing violation by Israel of the right of the Palestinian people to self-determination from its prolonged occupation, settlement and annexation of the Palestinian territory occupied since 1967. Distinguished members of the Court, Palestine has been subjected to the longest protracted state of occupation in modern history, as well as de facto and de jure annexation that confirm the unlawful nature of the occupation. Israel's persistent policy of implanting settlements in the West Bank and occupied Jerusalem for the purpose of creating facts on the ground and breaking up the territorial contiguity of the occupied territories is a blatant disregard for international law. 20 years ago, the representatives of the State of Palestine laid before this Court the facts of Israel's intensive settlement and colonization policy, which had, at the time, transferred 400,000 illegal settlers to the occupied Palestinian territories. Today, that number stands at 750,000, deliberately and permanently altering the status of the occupied territories. In addition to the policy of de facto annexation, Israel purported to annex East Jerusalem de jure through the basic law adopted by the Israeli Knesset in 1980, stipulating Jerusalem, complete and united, is the capital of Israel. The very limited number of states defending these policies advance two principal claims, namely that the legal status of occupation does not change if the occupation is prolonged or involves illegal violations of jus in bello, and that under jus ad bellum, Israeli occupation is lawful since, inter alia, relevant UN Security Council resolutions did not declare otherwise. Egypt submits that the proposition that occupation is merely a de facto situation whose legality cannot be called into question is seriously flawed. As highlighted by a number of participants, the legality of an occupation must be assessed by reference to the UN Charter and general international law. In fact, Israel's prolonged occupation violates a number of distinct legal regimes that exist and operate simultaneously and concurrently. These include, number one, the law of occupation, part of the jus in bello that was characterized by this Court as intransgressible. Number two, the jus ad bellum, and the peremptory prohibition of the acquisition of territory through force. Number three, the principle of self-determination, also a peremptory norm of international law, described by this Court as erga omnes and irreproachable in the East Timor case. And four, the fundamental prohibition of racial discrimination, segregation and subjugation. It is against this legal framework that the legality of Israel's policies and practices in the occupied Palestinian territories must be assessed. First, with respect to the jus in bello, it is a fundamental principle of international law that an occupying power is prohibited from changing the status of the occupied territory, as well as its annexation in whole or in part. It is only entitled to exercise limited powers intended to be temporary in nature, with the aim of balancing between its own military needs and the protection of the local inhabitants. These are not rights bestowed on the occupying power, but rather limitations on its authority. It flows from this that belligerent occupation is governed by two key principles. First, it is a temporary regime, and second, it cannot transfer sovereignty to the occupying power. Rather, it freezes the legal order of the occupied territory throughout the duration of the occupation. The occupying authority is merely a de facto administrator, a principle intended to protect both the inhabitants of the occupied territory as well as the separate existence of the state, its institutions and its laws. This is reflected in Article 47 of the Fourth Geneva Convention, and is precisely what distinguishes occupation from annexation. The prohibition of permanently changing the occupied territory extends also to its demographic component. Article 49 of the Fourth Convention prohibits individual or mass forcible transfer of civilians outside the occupied territory and the transfer by the occupying power of parts of its own civilian population into the territory it occupies. According to the 1958 commentary, this was intended to prevent a practice adopted during the Second World War by certain powers, which transferred portions of their own populations into occupied territory for political and racial reasons and in order, as they claimed, to colonize those territories. As demonstrated in Palestine's statement, there is overwhelming evidence that Israeli support for and maintenance of settlements is intended to permanently alter the demographic composition of the occupied Palestinian territory and extend Israeli sovereignty over it. This is coupled with Israel's mass forcible transfer and forced displacement of the Palestinians in Gaza through its illegal evacuation orders and indiscriminate use of force, which has been labelled by the UN Special Rapporteur on the situation of human rights in the occupied Palestinian territory as ethnic cleansing. It should be highlighted that Article 49 not only prohibits forced transfers, but also, in the court's own words, and I quote, "Any measures taken by an occupying power in order to organize or encourage transfers of parts of its own population into the occupied territory." Numerous resolutions of the General Assembly and Security Council affirmed the illegality of Israel's settlements, annexation, and measures altering the demographic composition, character, and status of the Holy City of Jerusalem, considering them invalid and a flagrant violation of the Fourth Convention, while requiring Israel to desist from such practices. Security Council Resolution 298 stated, and I quote, "All legislative and administrative actions taken by Israel to change the status of the City of Jerusalem, including expropriation of land and properties, transfer of population, and legislation aimed at the incorporation of the occupied section, are totally invalid and cannot change that status." The Council also declared in relation to Jerusalem in Resolution 478 of 1980 that Israeli legislative and administrative measures are null and void and must be rescinded forthwith. Israel remains in defiance of these and subsequent resolutions, including Resolution 2334 of 2016 and numerous General Assembly resolutions, in addition to the provisions of the Geneva Conventions previously described. Israel's prolonged military rule and its strategic settlement policy, considered a national value under Israeli legislation, is essentially a systemic de-Palestinianization of the occupied territory, including Jerusalem, intended to permanently change its demographic characteristics and enhance its Jewish component, thereby achieving the de jure and de facto annexation of that territory. This leads to the conclusion that Israeli occupation is, in fact, an illegal annexation, conquest, and de facto colonial endeavour. Mr. President, the second legal principle by which the legality of Israel's occupation is to be assessed is Article 2.4 of the UN Charter, which prohibits the acquisition of territory through force, one of the most fundamental principles of the post-UN Charter era. The vast majority of states participating in these proceedings submit that Israeli occupation, by virtue of its permanence, de jure and de facto annexation, manifestly violates the principle of inadmissibility of acquiring territory through force. Only one state has attempted to justify Israel's actions by contesting the Palestinians' title to the occupied territories and justifying Israel's territorial expansion as the product of a defensive war. Egypt submits that these claims have no basis in fact or in law, and seek to derail the court by raising issues outside the temporal scope of this request. They are reminiscent of the archaic international law of the 19th century that justified territorial conquest through denying the sovereign status of colonized peoples, relegating them to the realm of terra nullius. There is also no support for the proposition that Israel was acting defensively in 1967. International law recognizes neither preemptive nor preventive self-defense, and the terms of the UN Charter on this matter are clear, requiring an armed attack to occur in order to trigger the right of self-defense. Israel's attack in 1967 was therefore not a defensive but an aggressive war. Even if the claim of self-defense were valid, which clearly is not the case, a decades-long occupation is not reconcilable with the customary international law conditions of necessity, immediacy, and proportionality. In any event, the issue is a moot one, as it is universally recognized that a state may not gain title to territory through any use of force, regardless of its purported legitimacy. These claims also find no basis in Security Council Resolution 242, which unequivocally recognized the inadmissibility of acquiring territory through force, demanding Israel's withdrawal from territories occupied in the recent conflict, and emphasizing the duty of all states to act in accordance with Article 2.4 of the Charter. Resolution 242 was reaffirmed by Resolution 338, while the inadmissibility of territorial acquisition through force was confirmed in at least 9 subsequent Security Council resolutions. In fact, Resolution 471 clearly stated, as far back as 1980, the overriding necessity to end the prolonged occupation of the Arab territories occupied by Israel since 1967, including Jerusalem. In Egypt's view, it is clear that under international law, the territorial status of the West Bank, including Jerusalem and the Gaza Strip, cannot lawfully be altered through armed conflict. Israel's protracted occupation, which is coupled with measures to permanently change the demographic characteristics of the occupied territory and annex part of the land de facto and de jure in violation of the cardinal principle of the prohibition of the acquisition of territory through force, is therefore illegal per se and an ongoing violation of international law. Distinguished members of the Court, the third legal principle against which Israel's conduct must be assessed is self-determination. Egypt submits that Israel's indefinite occupation amounts to a nullification and denial of the Palestinian people's inalienable right to self-determination. It is indisputable that this right, enshrined in Article 1.2 of the UN Charter and both human rights covenants, is a cardinal principle in modern international law. Its erga omnes character, confirmed by the court in the East Timor case, entails that all states and international organizations have a legal interest and a duty in respecting and protecting this right. This court already affirmed in the Wall Advisory Opinion the applicability of this right to the Palestinian people. Mr. President, Israel's indefinite occupation of the Palestinian territories is, as a whole, inconsistent with the principle of self-determination and breaches three salient aspects of this principle. First, it obstructs the Palestinian people from freely determining their political status, achieving independent statehood, sovereignty, and the right of return. Second, it deprives Palestinians of their right to pursue their economic, social, and cultural development. In gross breach of international law, Israel restricts Palestinians' access to Jerusalem's Christian and Muslim holy sites, notably Al-Aqsa Mosque, wantonly depletes Palestinian natural resources, imposes access restrictions to Area C, and obstructs the movement of goods and people between the West Bank and Gaza, stunting Palestine's economy and impeding the geographical unity of the State of Palestine. Third, the fragmentation and dismemberment of the occupied territories through Israel's settlements policy, the wall, and measures of de facto and de jure annexation are a blatant violation of the fundamental principle of the integrity of the self-determination unit. The territorial unit of Palestine includes both the West Bank, including the holy city of Jerusalem, and the Gaza Strip. Although Israel withdrew its forces from Gaza in 2005, it still retains effective control by, inter alia, exercising complete control over Gaza's airspace and territorial waters, the flow of people and goods in and out of Gaza, the Palestinian population registry, the tax policy and transfer of tax revenues. Israel's continuing military incursions into Gaza, including the ongoing brutal assault, indicate Israel's continuing authority over the territory. Together, the West Bank and Gaza constitute a single territorial unit. This has been confirmed by numerous Security Council resolutions which refer to Gaza as an integral part of the territory occupied in 1967 and of the Palestinian state under the two-state solution. Egypt firmly denounces the ongoing obstruction of the Palestinian people's inalienable, permanent and unqualified right to self-determination, a violation as argued by Palestine that is an essential feature of Israel's prolonged occupation. One only needs to look at Israel's vicious wholesale destruction of Gaza today after years of imposing the medieval methods of siege and blockade to realize the extent of Israel's transgression of this principle. Israel's prolonged occupation is therefore illegal per se, and is an ongoing internationally wrongful act that must be immediately brought to an end by Israel by immediately ending the occupation. The fourth legal principle against which Israel's conduct must be assessed is the fundamental prohibition of racial discrimination, segregation and subjugation. On a daily basis under occupation, Palestinians face institutionalized discrimination and segregation under a dual legal system applying different laws to Palestinians and Israelis. Israeli military orders in the occupied territories entrench racial discrimination between Palestinians and Israeli settlers. Israel also implements de facto and de jure measures of racial discrimination, including in the areas of detention, criminal justice, housing, land confiscations, and house demolitions. How can such practices, which have been described by a number of participants as crimes against humanity, how can they be consistent with any notion of human rights and human dignity in the 21st century? Israel is under an obligation to repeal all such legislation that maintains its systematic, oppressive and institutionalized policy of racial discrimination and segregation against the Palestinian people, and to cease all discriminatory policies and practices. I now turn to whether self-defense or military necessity may justify Israel's prolonged occupation. The argument that a state may exercise self-defense against a territory under its own military occupation and effective control is counterintuitive, particularly since the occupying state has the authority and even the obligation to ensure public order and safety in the occupied territory. In the Wall Advisory Opinion, this court found that Article 51 of the Charter, which recognises the inherent right of self-defence, had no relevance, as the acts invoked by Israel were acts arising out of the occupied Palestinian territory, which is under Israeli effective control and not imputable to another state. Egypt finds no reason for the court to depart from this considered opinion in the current proceedings. The court also rejected the justification of military necessity. The modern conception of military necessity is strictly limited to the contexts in which it is expressly recognized. It is thus already considered in the formulation of the obligations set out in humanitarian conventions, some of which expressly exclude reliance on military necessity. For example, no military necessity qualification is permitted under Article 49, paragraph 6 of the Fourth Geneva Convention, which prohibits the transfer of any part of the occupying power's civilian population into an occupied territory. This cannot be justified as a safety measure taken by Israel in the exercise of its prerogatives as an occupying power. According to the legal maxim, ex injuria jus non oritur, one should not be able to profit from one's own wrongdoing. Israel thus cannot invoke self-defense to maintain a situation created by its own illegal conduct or to justify violations of peremptory norms of international law. Distinguished members of the court, for how much longer do the Palestinian people need to wait before they are able to exercise their legitimate rights under international law? For how much longer will the United Nations continue to manage the humanitarian impacts of Israeli violations without addressing their root cause? History will judge us for how we respond today. Egypt respectfully submits that the court should advise the General Assembly that, number one, the prolonged Israeli occupation is, per se, a continuing violation of international law for its breach of, number one, the jus in bello, number two, the prohibition of the acquisition of territory through force, number three, the right to self-determination of the Palestinian people, and number four, the prohibition of racial discrimination, segregation, and subjugation. Second, Israel, as the wrongdoing state, is obliged to make full reparation through restitution, compensation, and satisfaction, either singly or in combination, by ceasing immediately and unconditionally its unlawful occupation of Palestinian territory and rescinding the associated unlawful policies and practices of annexation, settlements, and discriminatory legislation. Three, all states have a duty not to recognize the illegal situation created by Israel's ongoing violation, resulting from its prolonged occupation, settlement, and annexation of the occupied territory, and not to render aid or assistance in maintaining that situation. Mr. President, the consequences of Israel's prolonged occupation are clear, and there can be no peace, no security, no stability, no prosperity in the Middle East without upholding justice and the rule of law for the Palestinian people. I thank you.
I thank the delegation of Egypt for its presentation. Before I invite the next delegation to make its oral statement, the court will observe a break for 10 minutes. The sitting is suspended. please be seated. The sitting is resumed. I now call upon the delegation of the United Arab Emirates to address the court and invite Her Excellency Lana Nusaybi to take the floor.
Mr. President, distinguished members of the Court, it is an honour and privilege to appear before you on behalf of the United Arab Emirates. The gravity of the situation we are called to address has compelled the UAE to participate in advisory proceedings for the first time in its history. Allow me to begin by affirming the UAE's recognition of the importance of the Court's advisory function in clarifying applicable legal frameworks contributing to peaceful relations between states. This is critical at a time of growing polarization over when and how international law is applied. International law cannot be an à la carte menu. It must apply equally to all. And it is all the more essential in the long shadow cast by the Palestinian question, an injustice that has persisted for more than 7 decades, and which implicates the most fundamental principles of the international system, of self-determination, of human rights, and of our most basic and universal yearning for peace, justice, and freedom. By responding to the General Assembly's request to render an advisory opinion, the Court will tangibly assist the Assembly's proper exercise of its functions in relation to the question of Palestine. It will also contribute to achieving a peaceful and just resolution of the conflict, included in the preservation of the parameters of the two-state solution, to which Member States have collectively subscribed. This is vital not only for Palestinians and Israelis, but for peace and stability in our region and beyond. The UAE strongly believes that the only path to that just and lasting peace is through the fulfillment of the long-denied right of the Palestinian people to self-determination with an independent and sovereign Palestine based on the 1967 borders, with East Jerusalem as its capital, living side by side with Israel. That right to self-determination and the duty of every member of the international community to cooperate in its fulfillment was expressly recognised in this Court's advisory opinion of 2004. Mr. President, rather than repeat the UAE's written statement of July 2023, I will elaborate on 5 key points here today. My first point addresses the significance of this advisory opinion to the realisation of the two-state solution. In so doing, I wish to respond to the claim that in providing an advisory opinion, the Court would hinder the negotiating process. I will then direct my second submission to the deteriorating situation in the occupied Palestinian territory since the written stage of these proceedings. Third, I will devote some time to East Jerusalem and Israel's violations there, including its annexation of territory and its undermining of the legal and historic status quo. Israel's violations in the West Bank, in East Jerusalem, and in the Gaza Strip imperil the two-state solution. The conclusion that flows from these violations is that Israel's occupation is illegal. This will be my fourth point. Finally, I will focus on the consequences of Israel's unlawful actions for Israel, for all states, and for the United Nations. I will now address the first point, the two-state solution. The General Assembly and the Security Council, through dozens of resolutions, have entrenched the two-state solution as the basis for peace. This vision necessarily includes the Gaza Strip as part of the Palestinian state, as reaffirmed most recently by the Security Council in Resolution 2720 of 22 December 2023. The viability of this vision of peace and of an independent Palestinian state are imperiled by Israeli violations that are the subject of the present proceedings. Since the General Assembly's request to the Court in December 2022, these violations and the level of violence have risen sharply. We convene today while Israel's grave violations against Palestinians persist with impunity, 4 months into its military operation in Gaza and following 4 failures by the Security Council to call for a ceasefire. Meanwhile, an increasingly brutal Israeli regime of systemic subjugation in the West Bank compounds Palestinian suffering. The horrors that have unfolded over the last few months, the 7th of October attack on Israel, the destruction of the Gaza Strip, and the oppression in the West Bank underscore the desperate need for realizing the two-state solution. In the context of this grim reality, the Court's advisory opinion is appropriate, it is urgent, and it is necessary. Far from prejudicing the negotiating framework, the Court's opinion will reinforce the contours of the two-state solution. Indeed, that solution must be consistent with international law. In the Wall opinion, the Court recognized that a negotiated solution and the establishment of a Palestinian state alongside Israel must be on the basis of international law. This is also what the Security Council reaffirmed most recently in Resolution 2720. These pronouncements make clear that a negotiating process could not and must not lead to a result that is contrary to international law. And it is self-evident that a negotiating process that results in the contravention of peremptory norms of general international law would be void. By their very nature, peremptory norms are non-negotiable. The fact that a solution is negotiated does not mean that it should not be principled. By responding to the questions posed by the General Assembly as regards Israel's violations and their consequences, the Court will be advising on legal questions directly relevant to the two-state solution. In so doing, the Court will aid efforts to realize the right of the Palestinian people to self-determination. This could not be more pressing. Moreover, as the State of Palestine observed in its oral statement on Monday, the Court's exercise of its advisory function can and has served to advance deadlocked negotiations, as occurred with its Chagos opinion. There is a similar need for the Court's advice on the Palestinian question, which is characterized by prolonged stalemate and frustrated negotiations, while Israel continues to change facts on the ground. Mr. President, the 56 years of occupation of Gaza and the West Bank, including East Jerusalem, have been shaped by Israel's consistent, grave violations against the Palestinian people. The UAE is confident that the Court has before it ample evidence to assist its identification of those violations and determination of their legal consequences. As I turn to my second point, I will outline briefly how the situation has severely deteriorated since July 2023. Under international law, the Gaza Strip is occupied territory. Gaza is also one of the most densely populated places on Earth. For over 4 months now, and after enduring 17 years of blockade, its population of over 2.2 million has been under siege, faced with severe restrictions on water, food, and other essential goods. The level of human suffering faced by civilians in Gaza, predominantly women and children, is on a scale seldom seen in the modern era. Israel's indiscriminate attacks on the Gaza Strip have caused massive civilian casualties and the extensive destruction of homes, schools, and hospitals. Some 75% of Gaza's total population is displaced. I note here, Mr. President, the latest orders issued to the Israeli Defense Forces to plan for the evacuation of Rafah ahead of another military offensive. That offensive would leave the approximately 1.5 million displaced Gazans taking refuge in the city with nowhere to go. These plans have been met with the international community's resounding rejection. Israel has imposed a policy of collective punishment against the Palestinian people in violation of Article 33 of the Fourth Geneva Convention. Israel has repeatedly issued so-called evacuation orders that in effect seek to transfer Palestinians forcibly in violation of Article 49 of the Fourth Geneva Convention. Israel has also failed its duty of ensuring the food and medical supplies of the population in Gaza in violation of Article 55 of the Fourth Geneva Convention. Israel has further failed to protect the wounded and the sick in violation of Article 16 of the Fourth Geneva Convention. Each passing day is met with further violations of international humanitarian law. And while the eyes of the world are trained on its brutal military operation in Gaza, Israel's violations in the West Bank have intensified. As submitted to the court, a number of Israeli acts in the West Bank, including East Jerusalem, constitute grave breaches under the Fourth Geneva Convention. Israel's conduct also violates the right of the Palestinian people to self-determination, which lies at the heart of these proceedings. 2023 was by far the deadliest year for Palestinians in the West Bank since the United Nations began keeping records, more than tripling the previous high in 2022. 2023 also saw the highest levels of settler violence yet recorded by the United Nations. The freedom of movement of Palestinians has been severely impacted, including for Palestinian farmers seeking to harvest their lands in the West Bank. Demolitions of Palestinian property have also reached their highest levels. This puts into stark relief the magnitude of this latest iteration of the Israeli settlement enterprise that erodes key components of the Palestinian people's right to self-determination, including the denial of access to ancestral lands and control over natural resources. In addition, there has been an intensification of Israeli settlement construction that undermines the viability of the two-state solution. According to the Secretary-General, 2023 saw the highest reported level of Israeli approvals and support for settler housing in the West Bank, including East Jerusalem. I raise these recent developments to underline that the violations at the core of the questions posed by the General Assembly are not static. After decades of violent dehumanization, dispossession, and despair, the breaches resulting from the Israeli occupation in all parts of the occupied Palestinian territory are worsening at an alarming pace. I will now focus on Israel's long-standing violations in East Jerusalem. Jerusalem is a city of unique cultural and religious depth and texture that has occupied, through history, a place at the crossroads of cultures and civilizations. The city of Jerusalem has the unique feature of being sacred for all three Abrahamic religions and is home to a host of holy places. This feature has put a special imprint on the city's character, and the international community has accordingly underlined the need to preserve Jerusalem's unique spiritual and religious dimensions. If Jerusalem has, throughout its long history, represented one thing, it is tolerance. In the words of UNESCO, more than any other place in the world, Jerusalem embodies the hope and dream of dialogue between cultures, civilizations, and spiritual traditions, a dialogue through which mutual understanding between peoples may flourish. Such is the unique historical nature of Jerusalem that an Israeli official once cautioned that anyone depriving Jerusalem of these contrasts, anyone upsetting the equilibrium by trying to make one factor predominant over another, would make Jerusalem cease to be herself. Jerusalem is a place of enormous significance to hundreds of millions of people worldwide. On account of their artistic, religious, and historical value, the Old City and the holy places are of exceptional importance to all humanity. Jerusalem's unique character has given rise to specific legal obligations as regards the rights of religious communities, including specific guarantees of access to the Christian, Jewish, and Islamic holy places. Since 1757, it has been the case that whoever holds Jerusalem is bound by this legal and historic status quo. As early as 1948, the Security Council urged all governments and authorities concerned to take every possible precaution for the protection of the holy places and of the city of Jerusalem, including access to all shrines and sanctuaries for the purposes of worship. The concerns that motivated the Council then still remain. In 2023, the Security Council called for upholding unchanged the historic status quo at the holy sites in Jerusalem, in word and in practice. Israel has, in agreements with Jordan and with the Holy See, committed to the historic status quo and freedom of access to the holy places in Jerusalem. In the Wall opinion, the court relied on such bilateral agreements, observing that they were part of the specific guarantees of access to holy places. It is therefore gravely disconcerting that Israel has taken and continues to take measures which undermine the special character of Jerusalem and erase its cultural heritage. Israel is in breach of its obligations by repeatedly interfering with the holy places and hindering freedom of access to them. Since the start of the occupation in 1967, Muslims and Christians have been impeded from worshipping at their holiest sites. Also in breach of the historic status quo are Israel's excavations in Jerusalem. Excavations and tunneling, particularly in and around the Old City, imperil its historical, cultural, and religious character. The works are carried out despite the serious risks to the integrity of Muslim and Christian holy places. The General Assembly has determined that these acts are flagrant violations of the Fourth Geneva Convention. Turning to the question of settlements, the ring settlements in East Jerusalem contribute to the further isolation of the city from the rest of the occupied Palestinian territory. They thereby undermine the viability of East Jerusalem as the capital of an independent Palestinian state. This is fast becoming a fait accompli. Mr. President, Israel's measures to extend its administration and laws to East Jerusalem are inconsistent with the most fundamental tenets of the law of occupation and the right to self-determination. Indeed, Israel's administration of East Jerusalem constitutes annexation of territory on which the Palestinian people have the right to self-determination. International law is unequivocal in this respect. All measures by Israel that affect or aim to alter the status of East Jerusalem are null and void and have no legal effect on its status. By Resolution 478 of 1980, the Security Council affirmed that Israel's enactment of the Basic Law was a violation of international law. Resolution 478 was plainly intended to be legally binding on Israel and all UN member states. A binding determination by the Security Council to the effect that a situation is illegal must have consequences. As the court noted in the Namibia opinion, it would be failing in the discharge of its judicial functions if it did not declare that there is an obligation to bring such a situation to an end. Israel's violations in East Jerusalem and throughout the occupied Palestinian territory threaten the viability of the two-state solution and go to the very nature of the occupation. It is in this context that I come to the legality of the occupation itself. The Security Council reaffirmed in 1980 the overriding necessity for ending the prolonged occupation of Arab territories occupied by Israel since 1967. The General Assembly has declared that the Arab territories occupied since 1967 have continued to be under illegal Israeli occupation. Israel's occupation is, as the vast majority of participants in these proceedings have recognized, illegal and must end. Israel's occupation breaches the requirement under the law of occupation that an occupation must be temporary and cannot become permanent. It is in breach of the cardinal principle enshrined in the Charter of the United Nations that the acquisition of territory by war is inadmissible. Israel's occupation, furthermore, violates peremptory norms of general international law, such as the Palestinian people's right to self-determination. Mr. President, whether the illegality of Israel's occupation is determined under general international law or under the Charter, the conclusion is the same. It is illegal. Israel's illegal acts cannot remain without consequence, which takes me to my last point. Mr. President, distinguished members of the Court, I will now address the legal consequences of the ongoing violations by Israel. I wish to draw the Court's attention to the obligations identified by the Court in the Chagos and Wall opinions. First, Israel has, inter alia, an obligation to comply with the primary obligations it has breached, an obligation to ensure cessation of those breaches, and an obligation to make reparation for the damage caused by those breaches. Let me illustrate these obligations with a few examples. This means that Israel must cease all policies and practices impeding the exercise of the Palestinian right to self-determination, and repeal all laws and regulations that aim to alter the demographic composition, character, and status of East Jerusalem. It also means that Israel must ensure freedom of access to the holy places and respect the legal and historic status quo. This means that Israel must comply with all its obligations as the occupying power in the occupied Palestinian territory in East Jerusalem, the West Bank, and the Gaza Strip. For example, Israel must bring into the Gaza Strip the necessary food and medical supplies to the Palestinian population, and it must end its siege and all practices depriving Palestinians of supplies essential to their survival. In practical terms, it must mean a ceasefire. It also means that Israel must stop its so-called evacuation orders and forcible transfers of Palestinians. It means that Israel must dismantle settlements in the occupied Palestinian territory and must prevent violence perpetrated by settlers, many of them armed, against Palestinians. And it means that Israel must put an end to its settlement activities, its confiscation of land, demolition of homes, and the transfer of new Israeli settlers to the occupied Palestinian territory. Finally, Israel must also comply with all decisions of the Security Council, in line with Article 25 of the UN Charter. This includes the binding decisions in Resolutions 478, 2334, 2712, and 2720. The UAE further submits that the erga omnes and jus cogens character of norms violated by Israel also give rise to obligations for all states. First, no state may recognize as lawful the situation resulting from Israel's unlawful conduct, nor render assistance to maintain such a situation. Second, states are under an obligation to cooperate to bring to an end Israel's serious breaches. Additionally, state parties to the Geneva Conventions must ensure respect for those conventions. These obligations may translate into different actions from one state to another. The UAE believes that diplomatic engagement and dialogue can be effective tools to encourage compliance and cessation of unlawful conduct. But where these tools fail, third states' obligations remain, as do the other instruments of the international system, including the General Assembly, the Security Council, and the court that sits in this great hall of justice. As the permanent representative of a country that has just completed its term on the Security Council, I wish to invite the court to consider the following. The obligations to cooperate and to ensure respect for international law carry implications for states in the exercise of their vote on the Security Council. Voting against or preventing the adoption of a Security Council resolution that seeks to put an end to serious breaches of international law cannot be compatible with such obligations. Israel's violations also have implications for international organizations. The organs of the United Nations can and should take all steps within their respective mandates with a view to ensuring an end to those violations. The UAE remains firmly committed to play its part in supporting the principles of international law which underpin the international system. The UAE considers that the court's advice on the questions before it is critical. Indeed, we believe it matters for all states, large and small, who rely upon and seek to preserve our international order. The reason it matters is quite simple. The even-handed application of international law is essential if that order is to function. To allow otherwise, to permit states to pick and choose what international law to apply and when, risks destabilizing our international order. Mr. President, distinguished members of the court, the Palestinian people have suffered for far too long under an occupation that is seemingly immune from international law. Palestinians and Israelis deserve to thrive side by side in their own independent, prosperous and secure states. This cannot happen if Israel's violations persist. Peace will remain elusive while the Palestinian people's inalienable right to self-determination continues to be denied. The UAE has every confidence that the court's opinion will contribute significantly towards achieving a peaceful resolution of this conflict in accordance with international law. Thank you.
I thank the delegation of the United Arab Emirates for its presentation. I invite the next participating delegation, the United States of America, to address the court. I call upon Mr. Richard Vizek to take the floor.
Thank you, Mr. President and members of the court. I am honored to appear before you today on behalf of the United States of America. The court has a serious and difficult task before it. In the time since the General Assembly first requested this advisory opinion, the international community has confronted the horror of the terrorist attacks of October 7, including the taking of hostages who have yet to be released, and the ongoing conflict between Israel and Hamas, which has had severe, widespread, and tragic consequences for Palestinian civilians in Gaza. Violence, including extremist settler violence, also surged in the West Bank. The United States, along with others, is engaging intensively with the Palestinians, with Israel, and with other states in the region and within the United Nations, not only to address the current crisis, but to get beyond where we have been, namely to advance a political settlement that will lead to a durable peace in the region that includes lasting security for Israelis and Palestinians and a path to Palestinian statehood. The Security Council and the General Assembly remain convinced that the Israelis and Palestinians must take the steps necessary to resolve their conflict and create such an enduring peace. These principal organs of the United Nations have laid out and continue to endorse the path to achieve that peace through the principles first articulated in Security Council resolutions 242 and 338. Those resolutions are the core of the established framework within which the court should address the legal questions before it. This court's advisory opinion will have consequences for the parties to the conflict and for the ongoing efforts of all of those working to achieve a durable peace. It will do so for the Security Council, which bears primary responsibility for maintenance of international peace and security. It will do so for the General Assembly, which requested the court's advice. And it will do so for the other members of the international community. Throughout the tumultuous and often violent history of the Israeli-Palestinian conflict, the United Nations has been consistent in its support for the proposition that a comprehensive, just, and lasting peace requires negotiations between the parties to the conflict. As the court can see in the submissions before it, there is broad international support for achieving a negotiated solution to the conflict that will give rise to a Palestinian state, a solution in which two peoples live side by side with equal measures of freedom, security, opportunity, and dignity, and which results in broader regional integration and stability with respect for the right of all states to live in peace within secure and recognized borders. It is for these reasons that the United States encourages the court to ensure that its opinion preserves and promotes the established framework and the prerogatives of the principal political organs of the United Nations to identify the appropriate measures to address this particular matter of international peace and security. Mr. President, members of the court, it will not be possible in this statement to address every assertion or underlying assumption, including those with which the United States disagrees. Instead, my statement today will proceed in two parts. First, I will discuss the established framework set forth and endorsed by the Security Council and the General Assembly, as well as the widespread recognition that the parties must return to that framework as the pathway to durable peace. I will then address guiding considerations for the important role the court should play in preserving and promoting that framework. Mr. President, members of the court, the first time the General Assembly sought this court's advice in relation to the Israeli-Palestinian conflict, the court recognized that, and I quote, "This tragic situation can be brought to an end only through implementation in good faith of all relevant Security Council resolutions, in particular resolutions 242 adopted in 1967 and 338 adopted in 1973. This statement remains as true today as it was then, as the Security Council, the General Assembly, and the international community have consistently affirmed, and as many of the submissions in these proceedings recognize. As set out in our written submissions, the established framework for achieving a comprehensive and enduring peace is anchored in Security Council resolutions 242 and 338. At their core, these and subsequent resolutions call for the application of two interdependent and inseparable requirements for a just and lasting peace. One is the withdrawal of forces from occupied territory, and the other is peace and security for states in the Middle East through acknowledgement of the sovereignty, territorial integrity, and political independence of every state in the area. In identifying these interdependent requirements, the Security Council decided that the withdrawal of Israeli forces relies on and is bound together with the termination of belligerency, mutual recognition and respect for the right of Israel and every other state in the region to live in peace within secure and recognized boundaries, free from threats or acts of force. This principle is referred to by both the Security Council and the General Assembly as land for peace. In the years since, these interdependent and inseparable requirements have been the organizing principle of historic peace agreements, first between Israel and Egypt, and then between Israel and Jordan. They were also adopted by Israel and the Palestinians in the Oslo Accords, though the promise of Oslo has yet to be fulfilled. The framework built upon these requirements remains the only basis for achieving a comprehensive peace in the region and between the parties. The Security Council and the General Assembly have reflected this time and again in their respective resolutions. This framework also remains the basis for ongoing U.S. efforts to facilitate a lasting peace. Earlier this month, U.S. Secretary of State Blinken traveled to the region for the 5th time since October 7 and discussed the sets of commitments that all parties would need to make. As he explained, there will be difficult choices necessary to realize the vision of a long, elusive prospect of true peace and true security. He also reinforced that the diplomatic path to a just and lasting peace and to true security for all in the region continues to be a path to an Israel that is fully integrated into the region with normal relations with the countries of the region and with firm guarantees for its security. He underscored that this must include a concrete path to a Palestinian state living side by side in peace and security with Israel. The United States is not alone in this effort to achieve and sustain the goal of the established framework that the Security Council and the General Assembly have created and continue to endorse. Countries and organizations around the world, some of which are participating in these proceedings, continue to reiterate the imperative of reviving the peace process and urgently achieving the two-state solution. Our written comments collect a number of statements made to that effect. Mr. President, members of the Court, I turn now to the second part of my statement and the important role the Court can play in preserving and promoting this established framework. The Court has appropriately recognized that its role in rendering an advisory opinion is to assist the requesting UN organ while taking care to avoid a result that could undermine the determinations of the Security Council and its primary responsibility for the maintenance of international peace and security. This feature of the Court's advisory function has several important implications for the Court's work in this proceeding. I will discuss 3 of them. First and fundamentally, the Court should not take up the suggestion of some to interpret the questions in this proceeding as encompassing the entire question of Palestine. The request seeks advice only with respect to the legal consequences of the conduct of one of the parties to the underlying conflict. This one-sidedness, which contrasts with the reciprocity inherent in the established framework, necessarily must inform the Court's approach to this advisory proceeding. Second, contrary to the assertions of some participants, in calling for the Court to take this measured approach to the question referred, the United States is by no means suggesting there is no role for the Court, nor is it the position of the United States that the Court must refrain from considering violations of international law or the legal consequences thereof. Participants who have said as much have misunderstood us. Our argument is grounded in respect for the UN Charter and the roles and responsibilities assigned to the UN's principal organs. The Court's advisory function was designed to assist the UN's principal political organs in the proper performance of their respective functions. In exercising its advisory role, the Court must necessarily consider the extent to which the Security Council and General Assembly have taken action to address a matter of international peace and security, particularly where, as here, they have directly and repeatedly endorsed a specific framework for achieving peace. None of the Security Council's resolutions has suggested altering or departing from this framework. In fact, as recently as late December, the Council, in Resolution 2720, reiterated its, and I quote, unwavering commitment to the vision of a two-state solution where 2 democratic states, Israel and Palestine, live side by side in peace within secure and recognized borders, consistent with international law and relevant UN resolutions, end quote. And at around the same time, the General Assembly likewise stressed in Resolution 78/192, quote, the urgency of achieving without delay an end to the Israeli occupation that began in 1967 and a just, lasting, and comprehensive peace settlement between the Palestinian and Israeli sides, based on the relevant resolutions of the United Nations, the Madrid Terms of Reference, including the Principles of Land for Peace, the Arab Peace Initiative, and the Quartet Roadmap to a permanent two-state solution to the Israeli-Palestinian conflict. International law has a central and important role to play here. Within the established framework, the Security Council itself, including in recent resolutions 2172 and 2720, has demanded that all parties comply with their obligations under international law, including international humanitarian law. And within the framework, the Council has also sought to remove obstacles to the achievement of a two-state solution, including the establishment of civilian settlements, destruction of infrastructure, demolition of homes, and the failure to prevent acts of terrorism. The Council has likewise emphasized that the parties should be held to their commitments. For example, Security Council Resolution 1850 notes the irreversibility of the bilateral negotiations between the parties and urges, and I quote, an intensification of diplomatic efforts to foster in parallel with progress in the bilateral process, mutual recognition and peaceful coexistence between all states in the region in the context of achieving a comprehensive, just, and lasting peace in the Middle East. In any consideration by the Court of these or other issues, the challenge for the Court is how to provide its advice in a way that promotes the framework rather than disrupting its balance, potentially making the possibility of negotiations even more difficult. In this regard, it would not, as some participants suggest, be conducive to achievement of the established framework to issue an opinion that calls for a unilateral, immediate, and unconditional withdrawal by Israel that does not account for Israel's legitimate security needs. Whatever the Court's opinion on the legal consequences of particular violations of international law, such an outcome would be contrary to the established framework, which the Security Council and General Assembly have structured around the two interdependent and inseparable elements, not only withdrawal, but also the conditions necessary for peace and security for all states in the region. An enduring peace requires progress on both of these balanced elements. In addition, as noted in the U.S. written comments, the establishment of this framework by the Security Council and General Assembly is a salient feature of these proceedings, distinguishing it from other proceedings. Mr. President, members of the Court, as Secretary General Guterres remarked just a few weeks ago in connection with ending Israel's occupation, quote, a lasting end to the Israeli-Palestinian conflict can only come through a two-state solution. Israelis must see their legitimate needs for security materialized, and Palestinians must see their legitimate aspirations for a fully independent, viable, and sovereign state realized, in line with United Nations resolutions, international law, and previous agreements. Under the established framework, any movement towards Israel's withdrawal from the West Bank and Gaza requires consideration of Israel's very real security needs. We were all reminded of those security needs on October 7, and they persist. Regrettably, those needs have been ignored by many of the participants in asserting how the Court should consider the questions before it. In sum, it is important that the Court keep in mind the balance that the Security Council and General Assembly have determined is necessary to provide the best chance for durable peace. Mr. President, members of the Court, I turn now to my third point. In carefully considering how its advice might best support progress within the established framework, the Court should not deviate from longstanding principles of international law, including with respect to the law of belligerent occupation. As set out in the written submissions of the United States, international law does not provide for an occupation itself to be rendered unlawful or void, based either on its duration or on any violations of occupation law. Under international humanitarian law, a belligerent occupation is established when the customary international law standard reflected in Article 42 of the Hague IV regulations is satisfied. The fact of an occupation is the basis for the occupying power to exercise its authority over occupied territory. The fact of an occupation is also the basis for the application of the legal rights and duties applicable to an occupying power. For example, the Fourth Geneva Convention prohibits an occupying power from transferring parts of its own civilian population into territory it occupies. Even if an occupying power violates such a prohibition, as has been argued in this proceeding and as the Court found in construction of a wall, the legal status of the occupation would not change as a consequence, because the occupation continues in fact. Importantly, this means that the protections of occupation law, including its protections for civilians, would continue to apply. We were surprised to hear that some have questioned in this proceeding the U.S. position on the illegality of acquisition of territory by the use of force. We have repeatedly stated our strong opposition to any unilateral attempts to change the peacefully established status of territories by force or coercion anywhere in the world, and have reaffirmed that the acquisition of territory by force is prohibited. And as our written statement made clear in reference to this and other situations, the Security Council and the General Assembly have declared that any actions to change the status of occupied territory are null and void and do not affect the continued application of the Fourth Geneva Convention. With respect to duration, international law does not impose specific time limits on an occupation. That said, belligerent occupation is a temporary measure for administering territory under the control of belligerent armed forces. A few days ago at the Munich Security Conference, Secretary Blinken emphasized that it is more urgent than ever to proceed to a Palestinian state, one that also ensures the security of Israel and makes the necessary commitments to do so. In light of these considerations, the Court should not find that Israel is legally obligated to immediately and unconditionally withdraw from occupied territory. The Court can address the questions before it within the established framework based on the Land for Peace principle and within the parameters of established principles of occupation law. Mr. President, members of the Court, as I said at the outset, you have a difficult task before you. Others have asked you to broadly construe the questions and the law. They have asked you to try to resolve the whole of the dispute between the parties through an advisory opinion addressed to questions focusing on the acts of only one party. The United States disagrees with that this approach would be consistent with the Court's role within the United Nations or the established UN framework for achieving peace through negotiations. Hamas's attacks, hostage-taking, and other atrocities, the ongoing hostilities and the suffering of Palestinians in Gaza, and the violence in the West Bank reinforce the United States' resolve to urgently achieve a final peace that includes the full realization of Palestinian self-determination. The current crisis illustrates the vital need to achieve this peace this final piece, with a Palestinian state living safely and securely alongside a secure Israel, fully integrated into the region. As Secretary Blinken said, quote, "We're not going to have durable security for Israel unless and until Palestinian political aspirations are met," end quote. The lack of meaningful progress on a negotiated end to the conflict and establishment of peace between the parties and for the region cannot and must not persist. The Security Council and General Assembly continue to make clear their support for the two-state solution and the established framework to fulfill it. This conflict cannot be resolved through violence or unilateral actions. Negotiations are the path to lasting peace. For these reasons, we respectfully encourage the Court to carefully calibrate its advice in this proceeding to support and promote final realization of peace and stability within the established UN framework set out in Security Council Resolutions 242 and 338. Mr. President, members of the Court, this concludes the oral statement of the United States. I thank you for your kind attention.
I thank the delegation of the United States of America for its presentation, which brings to a close this morning's hearing. The Court will meet again this afternoon at 3 p.m. to hear the Russian Federation, France, the Gambia, Guyana, and Hungary. The sitting is adjourned.
الشعب الفلسطيني بعد عقود من التهميش.
لو لم نكن نعتقد ذلك لما أتينا إلى محكمة العدل الدولية. نحن على قناعة تامة بأن هيئة القضاء لديهم من النزاهة ولديهم من الاستقامة ولديهم من المعرفة والجرأة والصلاحية ما يفوق كل أشكال الضغط والتنمر التي قد يتعرضون لها سياسيا أو غير ذلك. وبالتالي نحن لدينا كل الأمل الكبير أن يخرج عن هذه المحكمة ما يوفر العدالة المطلوبة والمنشودة من قبل الشعب الفلسطيني الذي احتاجها منذ أكثر من 75 عاما. نحن نعلم تماما بأن ما نطلبه هنا وما سوف يخرج هنا ليس كل العدالة المطلقة التي يجب أن يتم تقديمها للشعب الفلسطيني، وإنما هي عدالة جزئية، عدالة نسبية. ولهذا السبب نحن نتحدث عن دولة فلسطينية على حدود عام 67. لو أردنا العدالة المطلقة والعدالة الكاملة لكان الحديث ينطلق من مفاهيم أخرى مختلفة.
تعليق على كلمة الولايات المتحدة الأمريكية.
نعم،
تعليق على كلمة الولايات المتحدة الأمريكية.
لم يأتوا بجديد، هم أعادوا ما كتبوه في المداخلات المكتوبة، لم يتطرقوا إلى جديد. واضح تماما أن لديهم قلق كبير، هذا القلق انعكس في طبيعة المداخلة، وبالتأكيد هذا مؤشر مهم بالنسبة لنا. وهم يريدون إعادة الملف بالكامل إلى المجلس الأمن وإلى الجمعية العامة، وهم يدركون بأنهم لا يملكون أي صلاحية في محكمة العدل الدولية إلا إذا كان هناك ضغوط لا نعرفها موجهة باتجاه هيئة القضاء كل على حدة، ولكن لا نعتقد ذلك. أعتقد أن هناك ما يكفي من النزاهة والاستقامة والمسؤولية العالية والشجاعة والخبرة الكافية لدى هيئة القضاء لاتخاذ هذه القرارات المطلوبة والمناسبة. وبالتالي نحن نعتقد بأن ما جاء من قبل الوفد الأمريكي كان متوقعا ولم يخرجوا عن الإطار الذي حددوه لأنفسهم منذ اليوم الأول. نعم واضح تماما أنه كان موقفا سياسيا أكثر من ما هو موقفا قانونيا. تطرقوا إلى كلمات ومداخلات كثيرة لوزير الخارجية بلينكن في عديد المناسبات للتركيز على البعد السياسي في الموضوع بشكل كامل، لأنهم لو دخلوا في الإطار القانوني لفقدوا أي إمكانية للحديث بأي نقطة من هذه النقاط. وبالتالي هم ركزوا على البعد السياسي وحاولوا أن يطلبوا من المحكمة أن تكون أكثر اعتدالا وعدالة في النظر إلى الموضوع برمته. إذن أعتقد بأنه المداخلة ليست بجديد، مداخلة فيها بعد سياسي أكثر من قانوني، والمداخلة تؤكد على ضعف الموقف الأمريكي حيال ما يتم مناقشته هنا في محكمة العدل الدولية. Well, I expected much more. I didn't hear anything new. They repeated their written statement again. They focused on the political dimension rather than the legal one, and this is not the case here. But anyway, they even quoted Secretary Blinken more than twice, which really reflects, that where they stand is not that strong, and it's a reflection of certain weakness, because they have been requesting and asking that anything pertaining Israel-Palestine should be addressed in other forums and not here. But we tried the other forums for the last 75 years, and we confronted exactly them, the U.S. veto and the U.S. hegemony, over decision-making processes within the UN system. And that's why we came to the ICJ, because we felt that the Americans they cannot perform in the same way like they have really performed, in the United Nations system, because here we have judges who will decide based on their judgment, based on the facts, based on the legal system, based on international law, and based on what they have really heard and what they possess in terms of knowledge and experience.
The Netherlands had nothing to say about the situation in Israel and Palestine. They just talked about the law with no reference at all. Has the Netherlands changed its position?
Well, I cannot really speak about each and every presentation, but what I want really to say is that until this moment we did not hear any presentation that contradicts what we have really said and what we do expect. The majority until this moment and all presentations until this moment, they coincide very well with our expectation. We will try to hear Hungary this afternoon, and you know that Hungary is the agent and the representative of Israel within the European Union and beyond, and so we will see what they will say regarding this matter, but that won't make any difference because Hungary is being really labeled as an Israeli agent.
مع الوزير لو سمحت، هل فوجئت بالبيان الامريكي اليوم ام كنت تتوقعه؟
لا انا لم اتفاجأ.
You guys are saying anything? Kannst du mal kurz halten?
No.
If you want, if you speak, better and go. Let me know.
Okay. Errol, ich muss rein und den Edit machen. Es ist sehr.
Keine Karte mehr.
Okay. Es ist super unlikely, dass die das sagen. Ja? Aber sicher die Molly bleibt auch noch ein bisschen hier. Nee, du lässt die Karte hier. Ich muss nämlich das Hearing jetzt schneiden. Da würde ich dich hier draußen lassen.
Okay, ich warte einfach.
That was really interesting. So we wait for the Americans, yeah?
Yeah, I don't think they're going.
That's okay. We can wait here.
Is the American coming out?
They're not going to speak. They never speak.
No.
But they will come.
They'll come out. Get them on film, I guess.
Has the U.S. changed its position? I mean, they oppose the environment.
But I think what they said in court today was a bit more milquetoast than I suspected they were. You want to go back to
Yeah.
I'm not talking about
It's like what's going on in the environment.
There's nothing there anyway now. I mean, their stance on the law.
Shall I?
I don't think that's changed.
Peut-être le soir après.
We good. No more declaration.
So that's it.
Really good. Yeah.
No Americans.
They never talk. They never do anything.
They have discussion because they were so nervous of this guy. They were not able to step back one time. They just pushed him in front of him. I don't understand why. We have really good cameras. It's okay. So what's the problem?
So you'll move.
Non, j'avais oublié que j'arrête. Ja, de camera. Quelquefois ça va. On voit pas. No, it's fine. We got a response of nothing from the
Il y a les caméras de l'autre côté. Ouais, derrière. Mais on leur donne une. On va prendre déjà.
But it didn't reach me. They sent some sort of instruction for uploading the documents. I never.
Usually, all the documents that are sent to us, you are copied in.
Yeah.
We all copied it.
Yeah.
So that's why
Yeah,
I'm
I know. I'm surprised.
For people who doesn't understand
Есть эффективное толкование, очень сторонник подхода.
Can you make a look near? So it looks like anything coming from Dresser, your name is also there.
Please be seated. The sitting is open. The court meets this afternoon to hear the Russian Federation, France, the Gambia, Guyana, and Hungary on the questions submitted to it by the United Nations General Assembly. As I have had the occasion to note, each delegation is kindly requested to keep to the maximum speaking time of 30 minutes for its presentation. This afternoon, the court will observe a short break after the presentation of the Gambia. I shall now give the floor to the representative of the Russian Federation, His Excellency Mr. Vladimir Tarabrin. You have the floor, Excellency.
Mr. President, distinguished members of the Court, it's an honor for me to be representing the Russian Federation at these hearings. Seizing this opportunity, I would like to congratulate you, Mr. President, Madam Vice President, and all the new judges of the Court upon election to your respective positions. We trust that the Court, in its new composition, will continue making its immeasurable contribution to peaceful resolution of disputes and development of international law. Mr. President, the current proceedings originate in the adoption by the General Assembly of Resolution 77/247 back in December 2022. When adopting the resolution, the General Assembly was gravely concerned by the tension and violence in the recent period throughout the occupied Palestinian territories. The Assembly noted the continuing systematic violation of the human rights of the Palestinian people by Israel, the occupying power, including that arising from the excessive use of force and military operations causing death and injury to Palestinian civilians. The Assembly also spoke of the arbitrary imprisonment and detention of Palestinians, the use of collective punishment, the closure of areas, the confiscation of land, the establishment and expansion of settlements, the destruction of property and infrastructure, the demolition of Palestinian homes, the forced displacement of civilians, and the disastrous humanitarian situation and the critical socio-economic and security situation in the Gaza Strip. As has been stressed by numerous delegations speaking at these hearings, the situation on the ground has since deteriorated in a dramatic fashion. The Gaza Strip, since October 2023, has been an area of intense hostilities. This time, violence has taken an unprecedented and indeed a catastrophic scale. The overall number of victims during the current wave of violence, almost 30,000, has already surpassed the figure from any of the previous Arab-Israeli wars. Images from Gaza are terrifying. Indiscriminate airstrikes are killing civilians and erasing whole residential districts. More than half of all buildings in the Gaza Strip have been destroyed. Up to 90% of Gazans have been forced to leave their homes and are living in inhuman conditions. Against the backdrop of the tough Israeli blockade, the Gaza Strip is experiencing a genuine humanitarian catastrophe. Its inhabitants are suffering from an acute shortage of food, medication and fuel. Access to sources of clean water has been limited, resulting in a spread of infectious diseases. Over 20% of agricultural lands have been damaged and will never be recultivated. Mr. President, Russia, of all countries, understands the dangers of terrorism. We have faced this evil time and again. Let me use this opportunity to reiterate our heartfelt condolences to the Israelis who lost their loved ones in the attack on the 7th of October. Brutal massacre of innocent people taking of hostages, and other terrorist violence do not have and cannot have any justification. We have repeatedly condemned such acts. Let me also stress that Russia highly values the stable relations that we enjoy with Israel. We are united by shared history of combating Nazism, as well as by a myriad of present-day human ties. Our cooperation is resilient in the face of geopolitical turbulence, and we are committed to its further development. Having said this, we are convinced that the tragic events of the 7th of October cannot justify the collective punishment of more than 2 million Gazans. We cannot accept the logic of those officials in Israel and some Western countries who try to defend the indiscriminate violence against civilians by referring to Israel's duty to protect its nationals. Violence can only lead to more violence. Hatred brings hatred. This vicious circle must be broken. In Russia's view, security both for Israel and the Palestinians can only be ensured if the root cause of the current crisis is addressed. Outbreaks of violence will inevitably occur again until the Palestinian people, having suffered for decades from injustice, exercises its right to establish an independent state. That state, in accordance with the Security Council and General Assembly resolutions, is to emerge within the 1967 borders with East Jerusalem as its capital. Only this approach, based on international law, can bring a lasting peace for the region and security for Palestinians and Israelis alike. This is the spirit that we have, that has been guiding Russia in fulfilling its responsibilities as a mediator between Palestine and Israel, notably as a member of the so-called Quartet, alongside the United Nations, the United States, and the European Union. The history of the conflict shows what happens when Security Council resolutions are ignored and influential global actors are incapable of or unwilling to help the parties find consensual solutions. Attempts to put the conflict into a low-intensity mode instead of a comprehensive settlement have time and again provoked eruptions in the occupied territories. The current wave of violence is no exception. It was preceded by a persistent policy of the United States and its allies aimed at freezing the status quo, watering down the political processes, promoting a one-sided vision of a settlement. Among the victims of such short-sighted and irresponsible approach was the quartet of mediators, those of mediators whose work has been effectively blocked by the United States. This flawed policy of Washington has predictably led to a failure that has cost thousands of innocent lives. Today, all responsible members of the international community are facing a difficult task of creating conditions to lead the situation out of the current impasse. After the violent phase has been overcome, the parties will need help in establishing a full-fledged political dialogue, allowing them to settle all disputes on the universally recognized international legal basis. Russia hopes that the advisory opinion of the court will contribute to achieving this goal. Mr. President, a lot has already been said in this hall on the numerous violations of international law by Israel. Russia supports the assessments given in the General Assembly Resolution 77/247 and the respective reports of the Secretary General. We also support relevant resolutions of the Human Rights Council based on the reports of its Special Rapporteur. In today's statement, let me focus on two of the most important aspects. The first one, is the persistent denial by Israel of the right of Palestinians to self-determination. The right to self-determination through the establishment of an independent Palestinian state has been at the heart of efforts of the international community. This right has been recognized by the General Assembly, the Security Council, and by this court. It's worth recalling that the principle of self-determination of peoples is one of the foundations of the United Nations, mentioned in the very first article of its charter. Every state has the duty to refrain from any forcible action which deprives peoples of their right to self-determination. Meanwhile, as recognized by the General Assembly, the protracted Israeli occupation prevents the Palestinians from implementing that right. An end to the Israeli occupation has been identified as a goal for the international community by legally binding resolutions of the Security Council, including Resolution 2334. Israel is accordingly under an obligation to cease its violations of international law and to allow the Palestinian people to establish an independent state. This necessarily means that the occupation must come to an end. The other key problem that leads to continuous violations of human rights of Palestinians are the Israeli settlement activities. This policy, sometimes referred to as creation of facts on the ground, was launched back in 1967 and has led to progressive shrinking of Palestinian lands. This has effectively undermined prospects of a negotiated solution of the one element of the final status, namely the issues of territory and borders. The overall number of Israeli settlers in the West Bank, including East Jerusalem, is over 700,000. The situation is exacerbated by other arbitrary moves by the Israeli authorities, such as confiscation of lands, demolition of homes, and prohibition of new construction. Most recently, this has been accompanied by violence emanating from Israeli settlers. In 2023, that is after the present request for an advisory opinion was made, the settlement activities of Israel have gained a record-breaking speed. Thus, according to the latest reports of the United Nations Secretary General, in 2023, plans for more than 700,000 housing units were advanced, approved, or tendered. This is more than double than 11,700 units in 2022, which in itself was a remarkable figure. During the current wave of violence, we have witnessed public statements by Israeli cabinet members announcing plans to resume settlement activities in the Gaza Strip. Thus, on the 28th of January 2024, at a conference in West Jerusalem, cabinet ministers openly called for deportation of Palestinians from Gaza and presented a map with 21 settlement blocks. One cannot help noting that the event was held 2 days after this court indicated provisional measures in the South Africa versus Israel case. The court agreed that the situation in Gaza poses risks of irreparable harm to the rights of Palestinians guaranteed by the Genocide Convention. This fact alone underscores the gravity of the situation. In this connection, it's worth recalling that this court, in its advisory opinion on the wall, recognized that the Israeli settlement in the occupied Palestinian territory, including East Jerusalem, had been established in breach of international law. As explained in that advisory opinion, the settlements are contrary to the principle of inadmissibility of acquisition of territory by force. They also contradict the provisions of the Fourth Geneva Convention, prohibiting transfers of population and deportations from an occupied territory. Resolutions of the Security Council have characterized that policy as changing the legal status and geographical nature of the occupied territories and materially affecting their demographic composition. In its resolution 2334, the Security Council reaffirmed that the settlements have no legal validity and constitute a flagrant violation under international law and a major obstacle to the achievements of the two-state solution and the just, lasting and comprehensive peace. This policy is aggravated by numerous violations of other rules of international humanitarian law and human rights law. These include the right to life, to respect for private and family life, to property, to freedom of movement, to freedom of religion, to work, to health, to education, and to an adequate standard of living. As mentioned earlier, this policy continues unabated in defiance of Security Council resolutions and the Quartet roadmap. Importantly, as stressed in Resolution 2334, the settlements are dangerously imperiling the viability of the two-state solution based on the 1967 lines. They are thus also violating the right of the Palestinian people to self-determination. Israeli policies in Palestine, to Russia's deep regret, include other international law violations. Many examples have been provided by other delegations here. The Russian Federation expects the court to give them due consideration. Mr. President, members of the court, the question before us, therefore, the legal consequences of those violations. The starting point here is the well-established rule whereby every internationally wrongful act of a state entails the international responsibility of that state. In the present proceedings, the court will be right to conclude that Israel's violations result in Israel's duty to comply with the obligations it had breached, to put an end to its ongoing violations, and to provide reparation for the damage caused. This means, first and foremost, that Israel is under an international legal obligation to respect the right of the Palestinian people to self-determination and to stop all settlement activities in the occupied territory. Given the particular legal framework in the Middle East peace process, Israel is also under an obligation to cease all activities that impede reaching a final status agreement based on the right of the Palestinian people to self-determination in an independent, viable and contiguous Palestinian state with East Jerusalem as its capital. Having said that, the court will be wise not to engage in a detailed discussion on the precise scope and forms of implementation of Israel's responsibility. This is important for two reasons. First, advisory proceedings before the court are not an exercise in implementation of responsibility. No state is invoking Israel's responsibility in these proceedings, as indeed Israel is precluded from invoking responsibility of others. A state may only be brought before this court on the basis of its own consent. Full respect for the principle of consent is of crucial importance for the integrity of international judicial procedures. Secondly, the international community has established a solid legal framework for the Middle East peace process. This legal framework is a universally recognized and a legally binding one. It contains crucial elements that effectively coincide with the aims of international responsibility. A negotiated two-state solution with an independent, viable, and contiguous Palestinian state peacefully coexisting with Israel will be the best recipe for bringing an end to Israel's violations, creating guarantees of their non-repetition, and redressing the damage. The advantage of the peace process is an idea of direct negotiations between Israel and Palestine. They are to reach an agreement on the basis of their free will. In Russia's opinion, that significantly strengthens the chances that an agreement will actually be achieved, will indeed satisfy the interests of both parties, and will be implemented in practice. The Russian Federation invites the court to be guided by the need to contribute to creating conditions for successful final status negotiations. The best contribution would be a confirmation by the court that Israel and Palestine are under an obligation to resume such negotiations, while all states and international organizations shall cooperate in order to make that possible. In its written statement, the Russian Federation has discussed the status of the court as one of the principal organs of the United Nations. The court has on many occasions recognized that its advisory opinions represent its participation in the activities of the organization. When asked by the General Assembly to provide an advisory opinion, the court should give an opinion that would indeed be useful for the Assembly. For these reasons, we respectfully submit that the court, when giving an advisory opinion in this case, should be guided by the principles of the peace process and should actively seek to give an opinion that would contribute to their implementation. Mr. President, today I will not dwell upon issues of jurisdiction, admissibility, applicable law, or interpretation of questions put by the General Assembly. The respective chapters of the written contribution of the Russian Federation retain their full relevance. Let me now summarize our submissions. The continued Israeli occupation of Palestine impedes the realization of the Palestinian people of its right to self-determination. Israeli settlements are contrary to the principle of inadmissibility of acquisition of territory by force. They also run counter to the prohibition of transfer and deportation of population of an occupied territory. The settlement activities are aggravated by numerous other violations of international humanitarian law and human rights law. All states are under an obligation not to recognize the illegal situation resulting from Israel's violations. Israel shall terminate its breaches of international law. It must, in particular, cease all settlement activities and all other activities that impede reaching a final status agreement. At the same time, discussion on Israel's responsibility must remain within the limits imposed by the advisory nature of these proceedings and to the need to create conditions for successful final status negotiations. Israel and Palestine are under an obligation to conduct in good faith and without delay negotiations aimed at reaching a final status agreement. All states and international organizations are under an obligation to contribute to creating conditions for such negotiations. The agreement thus reached shall result in the implementation by the Palestinian people of its right to self-determination and emergence of an independent, viable, and contiguous Palestinian state, with East Jerusalem as its capital. This will bring an end to the ongoing violations of human rights of Palestinians and to the Israelis' occupation. Thank you, Mr. Chairman. Thank you, Mr. President.
I thank the delegation of the Russian Federation for its presentation J'invite maintenant la délégation de l'État participant suivant, la France, à prendre la parole devant la Cour et appelle M. Diego Colas à la barre. Monsieur Colas, vous avez la parole.
Merci. Merci, Monsieur le Président. Monsieur le Président, Mesdames et Messieurs les juges, c'est un grand honneur pour moi de représenter mon pays devant la Cour. Permettez-moi, en introduction, de revenir à mon tour sur le très lourd contexte dans lequel s'inscrivent ces audiences. Le 7 octobre 2023, Israël a connu une attaque terroriste d'une ampleur sans précédent. La France a condamné, dans les termes les plus forts, l'attaque perpétrée par le Hamas et les autres groupes terroristes et a exprimé sa pleine solidarité avec Israël et les victimes de cette attaque. Comme l'a fait la Cour dans son ordonnance en indication de mesures conservatoires rendue le 26 janvier 2024, la France appelle à la libération immédiate et inconditionnelle des otages enlevés par le Hamas et les autres groupes terroristes lors de l'attaque en Israël du 7 octobre. La France rappelle également le droit d'Israël à se défendre et à défendre sa population dans le but d'éviter que des attaques comme celle-ci ne se reproduisent. Ce droit doit s'exercer dans le strict respect du droit international et en particulier du droit international humanitaire. Alors que les opérations et bombardements israéliens font des milliers de victimes civiles à Gaza, la France a affirmé avec clarté, constance et de manière répétée cette exigence. La protection des civils et des personnels humanitaires est un impératif moral et une obligation internationale. Israël doit se conformer au droit international humanitaire qui impose en tout temps et en tout lieu des principes clairs de distinction, de nécessité, de proportionnalité et de précaution. J'ajoute que le respect du droit international, en particulier du droit international humanitaire, par toutes les parties prenantes, est le seul horizon de paix possible. La France a pris note des inquiétudes exprimées par la Cour dans son ordonnance du 26 janvier dernier, quant aux conséquences des opérations militaires qui se déroulent dans la bande de Gaza. Les préoccupations de la Cour sur, je cite, l'ampleur de la tragédie humaine qui se joue dans la région et sur les souffrances humaines que l'on continue d'y déplorer ne peuvent qu'être partagées par mon pays. Comme l'a rappelé le ministre français de l'Europe et des Affaires étrangères lors de son intervention au Conseil de sécurité des Nations Unies le 23 janvier 2024, il nous faut œuvrer immédiatement à un cessez-le-feu durable qui seul permettra de mettre fin aux souffrances de la population civile de Gaza. En rendant un avis consultatif dans le cadre de la présente procédure, la Cour peut apporter une contribution précieuse au règlement juste et durable du conflit israélo-palestinien. En effet, un avis de sa part pourrait utilement contribuer à la clarification du cadre et des paramètres juridiques applicables à cette situation. Ce sera ensuite aux parties prenantes, appuyées par la communauté internationale, qu'il incombera de rechercher par la négociation une solution de paix durable en conformité avec le droit international. À cet égard, la France réitère son soutien constant à une solution négociée à deux États, vivant côte à côte au sein de frontières sûres et reconnues, fondées sur les lignes du 4 juin 1967, ayant l'un et l'autre Jérusalem pour capitale. En effet, pour la France, seule une solution politique à deux États permettra de répondre à la fois aux droits des Israéliens à la sécurité et aux aspirations légitimes des Palestiniens à un État indépendant, viable et contigu, vivant dans la paix et la sécurité aux côtés d'Israël. Pour y parvenir, la France appelle à une relance décisive et crédible du processus de paix. La situation actuelle en Israël et en Palestine soulève un nombre important de questions de droit international. Seules certaines d'entre elles sont abordées par les questions posées par l'Assemblée générale et il importe de l'avis de la France que le champ de la présente procédure y soit précisément circonscrit. Il appartiendra dès lors à la Cour de fournir à l'Assemblée un avis l'éclairant sur les questions juridiques posées, sans aller au-delà de ce qui est nécessaire à cette fin. Monsieur le Président, Mesdames et Messieurs les juges, au regard de l'ensemble de ces éléments et suivant l'ordre des questions posées à la Cour, mon propos abordera les 5 points suivants. Le droit à l'autodétermination, l'occupation, colonisation et annexion, les lois et mesures discriminatoires, le statut de Jérusalem et les conséquences juridiques. Avant d'aborder ces 5 points, je ferai une remarque sur le droit applicable. Pour avoir une vision complète du cadre juridique pertinent pour la présente demande d'avis, il convient de souligner que la Palestine est depuis l'avis de 2004 devenue partie à plusieurs traités multilatéraux, dont une liste non exhaustive figure dans les observations écrites de la France. Premièrement, le droit du peuple palestinien à l'autodétermination a été rappelé par la Cour dans son avis rendu en 2004. Le Conseil de sécurité l'a également affirmé à plusieurs reprises. L'existence d'un peuple palestinien au sens du droit international ne saurait plus faire débat. À ce titre, comme tous les peuples, il bénéficie d'un droit à l'autodétermination. En vertu de ce droit, pour reprendre les termes de l'article 1er commun au pacte de 66, un peuple détermine librement son statut juridique et assure librement son développement économique, social et culturel. Ainsi, en ce qui concerne le peuple palestinien, ce droit a d'abord une dimension politique. Cette dimension a été largement consacrée par diverses résolutions de l'Assemblée générale. Elle se caractérise par le droit à un État de Palestine indépendant, son droit d'exercer sa souveraineté sur son territoire, d'accéder à l'indépendance dans son État, la Palestine. Cette perspective s'inscrit pleinement dans la vision d'une région dans laquelle les 2 États, Israël et la Palestine, vivent côte à côte à l'intérieur de frontières reconnues et sûres. Une solution de paix passera nécessairement par la conclusion d'arrangements de sécurité entre Israéliens et Palestiniens, prévoyant des garanties concrètes et efficaces. En même temps, ces garanties de sécurité ne pourront exister que s'il existe à l'avenir un véritable État palestinien à même de conclure de tels arrangements et de les faire respecter. C'est-à-dire un État capable d'exercer sa souveraineté pleine et entière dans ses frontières internationalement reconnues. Dans ce contexte, la France estime que toute action allant à l'encontre de la nécessité de préserver l'unité, la continuité et l'intégrité de l'ensemble du territoire palestinien occupé, y compris Jérusalem-Est, constitue une violation du droit du peuple palestinien à l'autodétermination. De ce point de vue, la poursuite de l'occupation, mais aussi le développement de colonies de peuplement et le morcellement qui en découle, entravent l'édification d'un État de Palestine viable. La perspective d'un tel État s'éloigne au fur et à mesure que les atteintes à l'intégrité des territoires palestiniens occupés perdurent et s'amplifient. Plus fondamentalement, la persistance des manquements imputables à Israël menace la possibilité pour le peuple palestinien d'exercer effectivement son droit à l'autodétermination. À cet égard, le constat dressé par la Cour en 2004 perdure, mais le passage du temps n'est pas neutre. Il obère les perspectives d'une concrétisation du droit à l'autodétermination du peuple palestinien. Près de 20 ans après l'avis consultatif rendu par la Cour sur les conséquences juridiques de la construction du mur en territoire palestinien occupé, le maintien de la situation d'occupation, la multiplication des mesures qui l'accompagnent et le développement des colonies de peuplement forment autant d'obstacles à la réalisation effective du droit à l'autodétermination du peuple palestinien. Deuxièmement, j'en viens maintenant à la question de l'occupation, colonisation et annexion prolongée du territoire palestinien occupé depuis 1967 par Israël. J'aborderai à cet égard 2 points. Les conséquences juridiques du caractère prolongé de l'occupation israélienne d'abord, puis le lien entre cette occupation prolongée et la question de la colonisation. Sur la question du caractère prolongé de l'occupation. L'occupation est une notion de fait objective qui se caractérise par le contrôle effectif exercée par un État sur un territoire déterminé. Depuis la fin de la guerre des 6 jours en 1967, Israël peut être considéré comme puissance occupante de la Cisjordanie, de Jérusalem-Est et de la bande de Gaza au sens de l'article 42 du règlement de La Haye de 1907, concernant les lois et coutumes de la guerre. Cette situation de fait, constatée par la Cour, ainsi que par le Conseil de sécurité des Nations Unies, suppose l'application des normes internationales prévues en cas d'occupation militaire. Ces normes internationales établissent des droits pour la puissance occupante, notamment pour préserver sa sécurité et ne pas compromettre les nécessités militaires. Mais elles lui imposent surtout des obligations positives, dont la principale est la protection des populations soumises à l'occupation. À ce titre, le Conseil de sécurité et l'Assemblée générale ont rappelé à maintes reprises les obligations d'Israël au titre de la 4e Convention de Genève relative à la protection des personnes civiles en temps de guerre du 12 août 1949. Ces normes internationales s'appliquent indépendamment de la licéité de l'opération ayant permis à l'État d'exercer son contrôle effectif sur le territoire occupé. Elles s'appliquent aussi indifféremment de la durée de l'occupation, et ce bien que celles-ci doivent être envisagées dans son essence comme temporaires. Ces obligations de protection s'appliquent, pour reprendre les termes de l'article 6 de la 4e Convention de Genève, pendant, je cite, la durée de l'occupation. Fin de citation. Avec une occupation des territoires palestiniens qui dure depuis 1967, ce caractère prolongé paraît difficilement pouvoir être justifié par les nécessités de guerre au sens de l'article 23G du règlement de La Haye de 1907. En effet, les circonstances justifiant l'occupation dans la période suivant immédiatement les opérations militaires ne peuvent plus être invoquées plusieurs décennies après la fin de ces opérations. C'est ce qui a conduit le Conseil de sécurité et l'Assemblée générale à demander aux forces armées israéliennes de se retirer des territoires occupés à plusieurs reprises depuis la résolution 242. De l'avis de la France, le caractère indéfiniment prolongé d'une occupation est contraire au fait que celle-ci devrait être provisoire par nature. Pour autant, l'occupation est une question de fait dont découle un régime juridique spécifique. Son caractère prolongé ne suffit pas à lui seul à la qualifier d'illicite. Le danger serait qu'un tel constat d'illicéité conduise à soutenir l'inapplicabilité du régime. Cela aboutirait à un résultat manifestement absurde ou déraisonnable où les populations civiles se verraient privées de la protection offerte par ce régime, protection pourtant d'autant plus nécessaire que la dite occupation perdure dans le temps. Une incertitude sur le cadre juridique applicable serait d'autant plus préjudiciable dans le contexte actuel des opérations militaires dans la bande de Gaza, territoire sur lequel Israël exerce maintenant un contrôle renforcé. Dans ce territoire, aujourd'hui, les populations civiles touchées doivent absolument et nécessairement pouvoir bénéficier des règles de protection minimale prévues par le droit de l'occupation. J'en viens au deuxième point, sur le lien entre l'occupation prolongée et la politique de colonisation des territoires palestiniens occupés. La colonisation de territoires occupés est contraire aux conventions de Genève. En ce sens, l'article 49 de la 4e Convention de Genève dispose que, je cite, « la puissance occupante ne pourra procéder à la déportation ou au transfert d'une partie de sa propre population civile dans le territoire occupé par elle ». Fin de citation. Le Conseil de sécurité a eu à plusieurs reprises l'occasion de dénoncer cette situation. Dans son avis de 2004, la Cour avait aussi conclu que, je cite, « les colonies de peuplement installées par Israël dans le territoire palestinien occupé, y compris Jérusalem-Est, l'ont été en méconnaissance du droit international ». Fin de citation. Ce constat d'illicéité demeure aujourd'hui d'autant plus fondé que depuis 2004, Israël a poursuivi et accéléré sa politique de création ou d'extension de colonies dans les territoires palestiniens occupés. Sur cette question, la France réitère sa ferme condamnation de la politique illégale de colonisation mise en œuvre par Israël, en particulier dans le contexte actuel. Cette politique, dont relèvent également les évictions de familles palestiniennes et la destruction de structures palestiniennes, doit cesser. La guerre à Gaza ne doit en aucun cas constituer un prétexte pour continuer à imposer sur le terrain des mesures unilatérales qui sapent les perspectives d'une solution à deux États, seule à même de garantir une paix juste et durable. Dans un communiqué conjoint du 15 décembre 2023, la France a réitéré, je cite, sa position relative à la politique de colonisation qui est illégale en vertu du droit international et rappelé à Israël les obligations qui lui incombent en vertu du droit international, en particulier l'article 49 de la 4e Convention de Genève. La France a également fermement condamné les violences commises par les colons extrémistes qui terrorisent les communautés palestiniennes. Fin de citation.
Suivre, donc si vous pouvez un peu
ralentir.
Merci.
Sur ce dernier point, la France a pris des mesures à titre national contre certains colons israéliens violents et s'est déclarée favorable à l'adoption au niveau européen de sanctions à leur encontre. Par ailleurs, il doit être rappelé que le statut de puissance occupante ne confère rigoureusement aucun titre juridique justifiant une annexion. À cet égard, le fait que l'occupation soit d'une durée particulièrement longue ne saurait en tout état de cause permettre de légitimer les prétentions d'annexion. Bien au contraire, l'un des principes cardinaux du droit international est celui prohibant ce type d'annexion. Comme cela ressort notamment de la résolution 26-25, je cite, « Nulle acquisition territoriale obtenue par la menace ou l'emploi de la force ne sera reconnue comme légale. » Fin de citation. Dans ce contexte, une annexion d'un territoire qui tenterait de se fonder sur le caractère prolongé d'une occupation ne pourrait être considérée que comme nulle et non avenue au regard du droit international. Troisièmement, la question posée par l'Assemblée générale vise également les conséquences juridiques des lois et mesures discriminatoires connexes adoptées par Israël. De l'avis de la France, cette question vise les lois et mesures appliquées au territoire palestinien occupé, mais en contradiction avec le régime international prévu pour les territoires occupés. Les lois et mesures qui présentent un caractère discriminatoire contreviennent non seulement aux dispositions des conventions précitées de La Haye et de Genève, mais également aux principaux textes internationaux en matière de droits de l'homme qui lient Israël et qui sont applicables au territoire palestinien occupé. La France relève que le droit international humanitaire n'exclut pas nécessairement qu'un statut différencié puisse s'appliquer à la population d'un territoire occupé. Ce statut ne peut cependant justifier l'adoption de lois et mesures qui présenteraient un caractère discriminatoire. Comme la Cour l'a précisé dans son avis de 2004, la protection offerte par les conventions régissant les droits de l'homme ne cesse pas en cas de conflit armé. Le droit de l'occupation doit donc être mis en œuvre en tenant compte du droit international des droits de l'homme applicable. La puissance occupante est en particulier tenue d'exercer ses droits et devoirs en tenant compte de l'obligation de non-discrimination, laquelle découle notamment de l'article 2 du Pacte sur les droits civils et politiques. La question posée à la Cour porte également sur les mesures visant à modifier la composition démographique du territoire considéré. De l'avis de la France, le droit international interdit clairement la mise en œuvre par la puissance occupante de mesures qui seraient de nature à modifier la composition démographique du territoire considéré. À ce sujet, la France réitère sa condamnation des propos promouvant l'installation de colonies à Gaza et le transfert de la population palestinienne de Gaza hors de ce territoire. La France rappelle que la Cour a énoncé l'obligation pour Israël de prendre toutes les mesures en son pouvoir pour prévenir et punir ce type de propos. Comme en Cisjordanie ou ailleurs, une telle modification de la composition démographique de la bande de Gaza constituerait en effet une très grave violation du droit international tant conventionnel que coutumier. Quatrièmement, Monsieur le Président, Mesdames et Messieurs les juges, j'en viens maintenant à la question du statut de Jérusalem. par plusieurs de ces résolutions, notamment la résolution 478 de 1980, le Conseil de sécurité a affirmé le caractère internationalement illicite des mesures prises par Israël pour modifier le statut de Jérusalem, y compris la loi fondamentale du 30 juillet 1980, qui proclame Jérusalem une et indivisible comme capitale de l'État d'Israël. La résolution 478 de 1980 rappelle que l'adoption de cette loi fondamentale ne remet pas en cause l'application de la 4e Convention de Genève. Il ne fait donc aucun doute que le statut unilatéral imposé par Israël à Jérusalem est nul et non avenu au regard du droit international. En outre, les mesures protectrices prévues par la 4e Convention de Genève doivent s'appliquer à Jérusalem, comme dans le reste des territoires palestiniens occupés. Dès lors, l'expropriation des terres palestiniennes à Jérusalem-Est, mais aussi les statuts dédiés aux habitants palestiniens de Jérusalem-Est, constituent autant de manquements à l'obligation pour la puissance occupante de prendre de telles mesures protectrices. En effet, ce ne sont pas seulement les mesures militaires qui contreviennent aux obligations d'Israël en tant que puissance occupante, mais aussi les mesures du droit civil israélien appliqué aux Palestiniens de Jérusalem-Est. Israël est, au regard du droit international, plus largement tenu de ne pas adopter de mesures législatives ou autres tendant à modifier le statut de Jérusalem. Comme le rappelle la déclaration présidentielle du Conseil de sécurité du 20 février 2023, la France considère qu'il convient de maintenir inchangé le statu quo historique sur les lieux saints à Jérusalem. Cinquièmement et dernièrement, la demande d'avis consultatif de l'Assemblée générale porte enfin sur les conséquences juridiques découlant des violations du droit international susceptibles d'être constatées par la Cour. À cet égard, il est utile de rappeler que, dans son avis de 2004, la Cour avait répondu en distinguant les conséquences juridiques pour Israël et celles pour les autres États, ainsi que, le cas échéant, pour l'Organisation des Nations Unies elle-même. Il en sera de même dans les présentes observations orales. En ce qui concerne Israël, la première conséquence juridique est l'obligation de cessation de l'illicite. Selon les termes de l'article 30A des articles de 2001 de la Commission du droit international sur la responsabilité de l'État pour faits internationalement illicites, l'État responsable d'un fait illicite a l'obligation d'y mettre fin si ce fait continue. L'examen de la situation dans les territoires palestiniens occupés fait apparaître des violations continues du droit international auxquelles Israël doit mettre un terme. Ces violations portent, on l'a vu, sur le droit des peuples à disposer d'eux-mêmes et sur les règles du droit international humanitaire et du droit international des droits de l'homme applicables à la situation dans les territoires palestiniens occupés. Sont notamment concernés les transferts de populations israéliennes dans le cadre de la politique illégale de colonisation menée par Israël et les mesures discriminatoires ou restreignant certains droits et libertés de la population palestinienne dans les territoires occupés. Cette obligation doit être rappelée avec d'autant plus de force que, dans le contexte des tensions actuelles, la politique de colonisation se double d'un accroissement des violences commises contre les Palestiniens de Cisjordanie. L'obligation de cessation a des implications tant juridiques que matérielles. Dans le cadre de la présente procédure, l'obligation de cessation implique que les politiques et pratiques identifiées comme violant le droit international prennent fin. Elle implique aussi que soient abrogés les actes juridiques internes sur lesquels elles sont fondées, ainsi que des actions positives pour garantir le respect du droit international. La deuxième conséquence juridique résultant d'une violation du droit international est la réparation. Dans le cadre de la présente demande d'avis consultatif, la France considère que cette obligation de réparation s'étend à l'ensemble des dommages causés à la population palestinienne du fait de la politique et des pratiques d'Israël ne respectant pas le droit international. En règle générale, l'obligation de réparation doit, autant que faire se peut, prendre la forme de la restitution, et à défaut celle de l'indemnisation si la restitution n'est plus ou pas possible. S'agissant de violations concernant le peuple palestinien dans son ensemble, des formes de réparation collective ou symbolique seraient envisageables. Enfin, au titre de la satisfaction, il conviendrait qu'Israël mène des enquêtes et poursuive, le cas échéant, les personnes responsables de violations graves du droit international humanitaire et du droit international des droits de l'homme commises dans les territoires palestiniens occupés. En ce qui concerne les autres États, la Cour avait déjà constaté dans son avis de 2004 le caractère erga omnes des obligations internationales violées par Israël à l'occasion de la construction du mur dans les territoires palestiniens occupés. Dans le cadre de la présente demande d'avis consultatif, le même constat s'impose à propos des atteintes aux droits des peuples à l'autodétermination découlant de l'occupation prolongée par Israël de territoires palestiniens, ainsi que de la politique et des pratiques menées dans les territoires palestiniens occupés. Il en résulte pour tous les États une obligation de non-reconnaissance de toute situation créée en violation grave du droit international. Toute forme d'annexion, y compris partielle, ne saurait ainsi être reconnue au regard du droit international. À cet égard, dans les territoires palestiniens occupés comme partout ailleurs, la France ne reconnaîtra jamais l'annexion illégale de territoire. Le respect du statut international des territoires palestiniens occupés emporte également des effets sur le plan économique. On rappellera à ce propos que dans sa résolution 2334 de 2016, le Conseil de sécurité des Nations unies a demandé à tous les États de faire une distinction dans leurs échanges en la matière entre le territoire de l'État d'Israël et les territoires occupés depuis 1967. Cela se traduit notamment dans le droit de l'Union européenne par la prise en compte du droit international et de l'avis de la Cour de 2004, afin de traiter différemment les produits en fonction de leur origine. En ce qui concerne les Nations unies, celle-ci pourra, comme cela fut le cas en 2004, préciser le cas échéant les suites à donner à l'avis de la Cour à propos du droit du peuple palestinien à l'autodétermination et des risques d'atteinte au statut international des territoires palestiniens occupés, notamment s'agissant des garanties offertes par ce statut à la population palestinienne. Enfin, il faut rappeler que la Cour avait demandé en 2004 à l'Organisation des Nations unies dans son ensemble de redoubler d'efforts pour mettre rapidement un terme au conflit israélo-palestinien afin d'établir une paix juste et durable dans la région. Cette demande de s'engager dans la voie de négociations de paix entre les parties prenantes, appuyée par la communauté internationale, reste plus que jamais pertinente. La France est prête à apporter son soutien à tous les efforts qui seront fournis dans ce sens. Monsieur le Président, Mesdames et Messieurs les juges, je vous remercie pour votre attention.
Je remercie la délégation de la France pour son exposé. I invite now the next participating delegation, the Gambia, to make its oral statement before the court. I thus call upon His Excellency Mr. Dawda Jallow to take the floor.
Mr. President, honorable members of the court, it is an honor for me to appear before you to present the Republic of the Gambia in these essential advisory opinion proceedings. As was the case with the Gambia's written statement, My oral submission today focuses on the second question presented to the court regarding the legal status of the occupation and the legal consequences that arise therefrom. The preamble of the UN Charter reminds us the fundamental goals of our international system: to save succeeding generations from the scourge of war, to reaffirm faith in fundamental human rights and the dignity and worth of human persons, in the equal rights of men and women and of nations large and small, to establish conditions under which justice and respect for the obligations arising from treaties and other sources of international law can be maintained, and to promote social progress, better standards of life, in large freedom. Mr. President, members of the court, notwithstanding the great resources invested by the international community at large, none of these goals have been achieved for the Palestinian people. None of them. And none of these goals can be achieved for the Palestinian people until Israel's illegal occupation of the Palestinian territories is brought to an end. My remarks today will focus on 3 points. First, I will discuss the fact that a belligerent occupation can be illegal per se under certain circumstances. Second, I will set forth 3 reasons why Israel's prolonged occupation of the Palestinian territories is illegal, a view shared by a substantial majority of the states participating in these proceedings. Third, I will conclude by emphasizing the essential role of this court in declaring that Israel's occupation is illegal and must be brought to an end immediately. As the court knows quite well, the international system is based on certain fundamental principles of law, which includes peremptory norms of international law or jus cogent norms. Adherence to these norms is not subject to derogation, and compliance with them is owed erga omnes to the international community as a whole. Some of the recognized jus cogent norms include prohibition of aggression, prohibition of genocide, the prohibition of apartheid, and the right to self-determination. If a particular action of a state violates one or more jus cogent norms, that action is illegal under international law. Any state may invoke the responsibility of that state for such a violation and seek an immediate end to it. This is fundamentally the situation regarding Israel's occupation in the Palestinian territories. The international community, collectively over many years, has found Israel's occupation of the Palestinian territories to be illegal, among other reasons on account of its violations of multiple jus cogent norms. And collectively, we have invoked Israel's responsibility in that regard to end the occupation. Mr. President, at least one state in the course of these proceedings has suggested that an occupation under international law cannot be illegal under any circumstances. This argument posits that an occupation exists, therefore it's legal. The proposition is unfounded in international law and fails for several reasons. First, this argument confuses jus in bello and completely ignores the jus ad bellum. As the court is well aware, international humanitarian law and the jus in bello is the body of law that governs the ways which warfare can be conducted. It includes within it the law of occupation, a body of rules regulating the conduct of occupying power. It is indeed true that the obligations under jus in bello, as they relate to an occupation, persist throughout the pendency of the occupation. But separate from jus in bello is the jus ad bellum, or the conditions under which state may resort to armed force. It is the jus ad bellum that addresses the legality of use of force, including an occupation, which is maintained by ongoing use of force. Article 2(4) of the UN Charter prohibits the threat or use of force in any manner inconsistent with the purpose of the United Nations. The only exceptions to this prohibition are the very narrow circumstances of the force authorized by the UN Security Council or self-defense under Article 15 of the Charter. Any use of force outside of these narrow exceptions, that is, any any annexation or occupation of territory arising from an act of aggression or otherwise unlawful use of force is illegal. Any use of force that is unnecessary, disproportionate to the threat against which it is exercised is also illegal under jus ad bellum. Second, the proposition that an occupation exists, therefore it is legal, also ignores the existence and implications of jus cogent norms going beyond the jus ad bellum. If an occupation inherently violates one or more jus cogent norms, then it is illegal as a whole, and the occupying power's responsibility for that violation can be invoked in order to bring the violation to an end. The occupying power's ongoing obligation under international humanitarian law do not and cannot preclude the wrongfulness of jus cogent violations inherent in the occupation itself. For example, the argument that occupations are inherently legal, if adopted, would directly conflict with and undermine the prohibition on the annexation of territory. Any state that wanted to de facto annex a territory could do so by indefinitely occupying that territory, but not formally incorporating it within its borders. It is the same with the jus cogent norms of the rights of self-determination. Simply put, flagrant violations of international law cannot be brushed aside by the fig leaf of occupation. Finally, the thesis that an occupation exists, therefore it is legal, also ignores the fact that the court has determined occupations to be unlawful in the past. As discussed in the Gambia's written statement, this was the case regarding South Africa's occupation of Namibia without title, and regarding Uganda's occupation of the Congolese province of Ituri. The UN Security Council and the General Assembly have characterized occupation resulting from unlawful uses of force to be illegal as well. In sum, a belligerent occupation can be illegal per se if it violates the jus ad bellum and other jus cogent norms. Mr. President, members of the court, the Gambia will highlight 3 reasons why Israel's prolonged occupation of the Palestinian territories is illegal. All 3 of these reasons, the right of self-determination, the prohibition on apartheid, and the jus ad bellum, reflect obligations rooted in jus cogent norms. This conclusion of illegality is shared by a substantial majority of the participants in these proceedings, many for the same reasons as the Gambia. First, Israel's occupation violates the right to Palestinian people to self-determination and is therefore illegal. Their government's right of self-determination is one of the essential principles of contemporary international law and jus cogent norm enshrined in the UN Charter. The court has before its extensive and uncontested fact-finding, the court has before it extensive and uncontested fact-finding multiple UN mandate holders, including the Independent International Commission of Inquiry on Occupied Palestinian Territory and the many reports of the Special Rapporteur on the situation of human rights in Palestinian territories occupied since 1967. These reports have been produced by independent UN mandate holders who engage in extensive fact-finding utilizing multiple sources of evidence. The court should accept these reports as conclusive and convincing evidence of Israel's long-standing, ongoing, and indefinite infringement on the right of self-determination for the Palestinian people. Indeed, there is no end in sight to Israel's occupation. Already extending over 56 years, Israel's current leadership boasts with pride its long-standing efforts to prevent the creation of an independent Palestinian state. As reported by the UN Special Rapporteur, Israel's occupation violates Palestinians' ability to organize themselves as a people, free from alien domination and control. No derogation is permitted from respecting the right of the Palestinian people to self-determination. There is no escaping the conclusion that Israel's occupation is illegal for violating the right of the Palestinian people to self-determination, and that it must expeditiously be brought to an end. Second, Israel's ongoing occupation of the Palestinian territories is also illegal because it amounts to a regime of apartheid, the prohibition of which is a peremptory norm of international law. This court has described apartheid as flagrant violation of purposes and principles of the Charter. Once again, the court has before it extensive, credible, and independent fact-finding demonstrating conclusively that Israel has imposed an apartheid reality in the Palestinian territories. This is clear in the reporting of the UN Special Rapporteur, who concluded that Israel has imposed upon Palestine an apartheid reality in a post-apartheid world. This is also reflected in the findings of the Committee on the Elimination of Racial Discrimination. Senior international leaders like Ban Ki-moon, Desmond Tutu, and former Israeli officials, including former Attorney General, former Director of Israel's Intelligence Service, Sin Bet, and former Ambassador of Israel to South Africa, have also concluded that Israel's occupation constitutes a regime of apartheid. The most credible non-government human rights organizations that report on the situation in the occupied Palestinian territory have also concluded that the occupation is, in fact, and in law, apartheid regime. A sober review of the uncontroverted evidence convincingly shows that the occupation is a regime of apartheid. As such, Israel's occupation of the Palestinian territories is illegal and must urgently be brought to an end. Third, Israel's 56-year occupation of Palestinian territories violates the laws on the use of force, jus ad bellum, and is illegal for that reason as well. As discussed earlier, the prohibition on the threat and use of force as a jus cogent norm, even then resort to force is justified by self-defense in response to an armed attack. The particular force used may still be illegal if it is unnecessary or disproportionate to the threat against which it is exercised. Israel launched the June 1967 war that led to its occupation of the Palestinian territory. After its surprise attack initiating the war, Israel occupied all remaining Palestinian territory in the West Bank, including East Jerusalem, the Gaza Strip, as well as Syria, Golan Heights, and Egypt in Sinai Peninsula, effectively tripling the size of the territory under its control. Since this use of force was not taken in response to an armed attack and was not necessary or proportionate even if it had been, the occupation was flagrant violation of the laws of the use of force from the onset. Furthermore, even if the occupation of the Palestinian territories were lawful at one time, its continuation for more than 5 decades means that it could not possibly still be lawful today. First, the use of force in self-defense is only justified within the strict confines laid down in Article 51 of the Charter and does not allow the use of force by a state to protect perceived security interests beyond those parameters. As such, essentially, preventive use of force are beyond the scope of Article 51. Second, as clarified in the World Advisory Opinion, Secondly, as clarified in the World Advisory Opinion, Article 51 does not apply to situations involving conduct taken in response to purported threats emanating from the within occupied territory. Israel therefore cannot justify its occupation as a response to illegal threats emanating from within the occupied Palestinian territory itself. Israel's ongoing occupation of the Palestinian territories also violates the jus ad bellum because its maintenance is unnecessary and disproportionate. It is simply not possible that it has been necessary for Israel to maintain its occupation since 1967 for over 56 years. Moreover, Israel also cannot possibly justify its settlements upon an annexation of occupied territory as a necessary response to any perceived threat not to mention the myriad of rights violations that are intrinsic to the occupation. By settling and annexing occupied territory, Israel has acted unnecessarily in using force. Israel's prolonged occupation is also wholly disproportionate to any legitimate aim. Israel's occupation of the entirety of the Palestinian territories, long after the period in which they presumed armed attack could reasonably be contemplated, makes it even more disproportionate now. And the manner in which the occupation has been conducted, including the establishment of an apartheid regime, renders the occupation disproportionate as well. In sum, Israel's decades-long occupation violates the jus ad bellum and is therefore illegal. Mr. President, members of the court, in the almost 20 years since the Wall Advisory Opinion, Israel has only deepened the occupation. Israel has annexed more territory and expanded its illegal settlements. It has further fragmented the Palestinian territory. In Gaza, Israel has decimated the territory and the Palestinian population there. In the territories overall, Israel has entrenched an apartheid regime. The Palestinian people continue to be deprived of their right to self-determination indefinitely. And all the while, there is no justification under international law for Israel's continued use of force to maintain the occupation, if there ever was one to begin with. Mr. President, members of the court, I remind us of the fundamental goals of the United Nations that I recited at the beginning of my remarks. If we are to ever achieve any of those goals in regard to the Palestinian people, then this court must play its role in robustly answering the question posed by the General Assembly. As to the second question posed, the Gambia submits that the court should find Israel's occupation of the Palestinian territories is illegal per se for all of the reasons discussed. And the Gambia further submits that the court should find that Israel, all other states, and the United Nations are under an obligation to bring about an end to Israel's occupation immediately, or at least as rapidly as possible. Thank you, Mr. President, members of the court, for your kind attention.
I thank the delegation of the Gambia for its presentation. Before I invite the next delegation to make its oral statement, the court will observe a break for 10 minutes. The sitting is suspended.
hearing. Although situated far from the Middle East, Guyana has a close interest in the legality of Israel's occupation of Palestinian territory. Israel's activities in the occupied territory, which have been brought into sharp focus by the tragic and ongoing humanitarian catastrophe in Gaza, are a matter of truly global concern, with significant implications not only for the state of Palestine and the Palestinian people, but for all states opposed to the acquisition of territory by force. Israel's continued occupation of Palestinian territory is an offence against this bedrock principle of international law, and it is a serious and a continuing threat to a peaceful, secure and stable world. Guyana's participation in these proceedings and its presence here today reflect its firm conviction that an advisory opinion by the Court on the questions posed by the General Assembly will play a valuable and indeed vital role in enabling the United Nations and all of its member states to secure full compliance with international law and ultimately to achieve a permanent, just and peaceful settlement of the Israeli-Palestinian conflict. Mr. President, that belief is one that is shared by the overwhelming majority of states and international organisations which have chosen to participate in these advisory proceedings. However, a small number of states, just 5 in total, contend that the Court should decline to provide an advisory opinion because, they say, an opinion would prejudice negotiations between the State of Palestine and Israel. A further handful of states, which include the United States, from whom you heard earlier today, do not go quite so far, but they instead urge the Court to exercise caution to avoid undermining the existing negotiating framework. Both the advocates of abstention and the advocates of timidity are wrong. There are several reasons why the possible effect of an advisory opinion on negotiations between Israel and the State of Palestine does not constitute a good, still less a compelling, basis for either declining to issue an opinion or for restricting its scope. I highlight 2 in particular. First, the arguments all rest on a fundamentally flawed factual premise. They assume the existence of ongoing negotiations between Israel and the State of Palestine, which could be prejudiced by an advisory opinion. But such negotiations do not exist. There have been no negotiations between the 2 states for a decade. There are no live negotiations. And this is not a contentious proposition. Indeed, one of the most prominent and vocal advocates of judicial caution, the United States, expressly concedes in its written statement that negotiations between the 2 states are not currently occurring. This is the unfortunate but very real actuality. Nor, if the words of Israel's leaders are anything to go by, is there any realistic prospect of Israel's willing participation in such negotiations in the near future. Recent public statements by Israel's Prime Minister make this abundantly clear. In November of last year, for example, Prime Minister Netanyahu proclaimed that Israel would prevent a Palestinian state in Gaza and the West Bank. That was a position that he reiterated emphatically in January of this year. The second and more fundamental reason why the Court should not be deterred from issuing an advisory opinion which answers in full the questions posed by the General Assembly is that the General Assembly, the Security Council and this very Court have all made clear that the Israel-Palestine conflict must be and can only be resolved in accordance with international law. In November 2022, for example, the General Assembly adopted Resolution 7725, which, and I quote, stressed that compliance with and respect for the Charter of the United Nations and international law is a cornerstone of peace and security in the region. The General Assembly called upon Israel to comply strictly with its obligations under international law and to cease all of its measures that are contrary to international law, including measures which seek to prejudge the final outcome of peace negotiations. The resolution went on to refer to, I quote, the illegality of the annexation of any part of the occupied Palestinian territory, which constitutes a breach of international law and challenges the prospect for the achievement of a just, lasting and comprehensive peace. In other words, a just, lasting and comprehensive peace necessarily requires compliance with international law. In a similar vein, in February of last year, the President of the Security Council issued a statement which emphasised that, I quote, the Security Council reaffirms its unwavering commitment to the vision of the two-state solution where two democratic states, Israel and Palestine, live side by side in peace within secure and recognised borders, consistent with international law and relevant UN resolutions. The Security Council strongly underscores the need for all parties to meet their international obligations. In the Wall opinion, the Court likewise stressed the importance of, quote, achieving as soon as possible, on the basis of international law, a negotiated solution in order to achieve peace and security for all in the region. In his concurring opinion in that case, Judge Al-Hassaneh stressed that, quote, it is of the utmost importance, if negotiations are not to produce non-principled solutions, that they be grounded in law. The principal judicial organs of the United Nations have spoken emphatically and with one consistent voice. They could not be clearer that any negotiations between Israel and the State of Palestine must be grounded in international law and must be aimed at ensuring a resolution of the conflict which is in accordance with international law. It is obvious and it is self-evident that an advisory opinion containing the Court's answers to the questions of international law posed by the General Assembly will help, not hinder, the attainment of that end. Indeed, the very resolution which requested these advisory proceedings confirms that this is exactly what the General Assembly considers that an advisory opinion will help to achieve. Resolution 77247 stressed the need to, I quote, advance and accelerate meaningful negotiations aimed at the achievement of a peace agreement that will bring a complete end to the Israeli occupation and the resolution of all core final status issues, leading to a peaceful, just, lasting and comprehensive solution of the question of Palestine. In adopting this resolution, the General Assembly plainly considered that an advisory opinion from the International Court of Justice would facilitate, rather than frustrate, negotiations leading to a peaceful, just, lasting and comprehensive solution. It follows that the Court can and should answer the questions posed by the General Assembly, confident in the knowledge that its answers will help to achieve a peaceful resolution of the conflict in accordance with international law. Mr. President, I turn now to an important issue of substance, namely whether as a matter of international law an occupation can be unlawful. The United States, as you heard earlier, contends that an occupation cannot be unlawful or lawful. It argues that occupation is governed exclusively by international humanitarian law, which is concerned only with the acts of the occupying power and has nothing to say about the legality of the occupation itself. For the United States, when it comes to occupation, international humanitarian law is both the start and the end. It is the only game in town. Guyana, like dozens of other states and international organisations, disagrees. Put simply, there is a distinction between the law of occupation on the one hand and the legality of an occupation on the other. The conduct of an occupation is governed by international humanitarian law, while the legality of an occupation as a whole is determined by the United Nations Charter and general international law. The argument advanced by the United States that occupation is governed solely by international humanitarian law leaves no room for the application of the Charter or general international law. In particular, it leaves no room for the principle enshrined in Article 2.4 of the Charter that acquisition of territory by force is absolutely prohibited. An argument which leaves no room for the application of that fundamental principle of international law, a peremptory norm, is not a sound one. How then does one determine whether Israel's occupation of Palestinian territory is unlawful? The answer, Guyana submits, is straightforward. It is to be found in the principle that occupation is inherently and exclusively a temporary state of affairs, and in the Jus Cogens prohibition on acquisition of territory by force. The inherently temporary character of occupation is reflected in the principle that an occupying power does not acquire sovereignty, not one atom, as Oppenheimer memorably put it, over the occupied territory. It is also reflected in the duty of the occupying power to preserve the status quo ante and to refrain from making any permanent changes to the occupied territory. Temporariness, in short, is the very core and essence of occupation. And it is notable that none of the 57 states and international organisations which filed written statements in these proceedings contend otherwise. It follows that permanent occupation is not occupation at all. It is military conquest. It is annexation. And annexation is, of course, strictly forbidden under international law. It therefore necessarily follows that an occupation which is intended to be permanent is unlawful under international law. Applying these principles, Guyana submits that it is indisputable that Israel's occupation of Palestinian territory is unlawful as a whole. The unlawfulness arises from the fact that Israel has annexed most of the occupied territory, de jure and de facto, including by implanting almost 750,000 Israeli settlers in hundreds of settlements, which Israel's leaders have promised never to remove. In Jerusalem, Israel has formally declared sovereignty over the occupied territory and has expressly extended the application of its domestic laws to that territory. This is a classic, quintessential example of de jure annexation, and it is irrefutable evidence that Israel intends its occupation to be permanent. Over many years, Israel's leaders have repeatedly proclaimed East Jerusalem to be an inseparable part of Israel. In the words of Israel's current Prime Minister, East Jerusalem has been and always will be ours, and will remain only under Israel's sovereignty. This unequivocal declaration and many others like it, have been accompanied by far-reaching actions. These include the systematic implantation of more than 230,000 Israeli settlers in East Jerusalem, an exercise in deliberate demographic manipulation that has profoundly changed the composition, the character, and the status of the Holy City. In the rest of the West Bank, Israel has conducted a similar decades-long process of implanting 500,000 Israeli settlers in more than 270 illegal settlements. Those settlements and the network of settler-only roads and infrastructure which connect them form a vast, interconnected constellation of illegal colonies to which Israel has extended the application of its domestic laws. The intent and the effect is to establish permanent Israeli dominion throughout the West Bank. Indeed, the highest officials in successive Israeli governments have openly and brazenly declared an intention to exercise sovereignty over the entire West Bank, which they have renamed Judea and Samaria, and which they define as an integral and inseparable part of the land of Israel. Israel has created, expanded, and entrenched its sprawling network of settlements in the face of repeated condemnation of the illegality of those actions by the General Assembly, the Security Council, the Secretary-General, a plethora of UN committees and rapporteurs, as well as the international community and, of course, this very court. Israel's annexation of the occupied territory and its intention for the occupation to be permanent has been widely recognised and condemned by the United Nations. I offer 5 examples, but I stress that these are merely illustrative and they are very far from exhaustive. First, literally dozens of General Assembly resolutions from the early 1970s onwards have expressly referred to and condemned Israel's, quote, annexation of the occupied territory. Examples of those resolutions, which span a period of more than half a century, are listed in Guyana's written statement. This vast corpus of resolutions demonstrates a clear, consistent, and emphatic recognition by the General Assembly that Israel has unlawfully annexed much of the occupied territory with the intention of retaining it forever. Second, multiple resolutions of the Security Council between 1968 and 2016 expressly recalled the prohibition on acquisition of territory by force and condemned Israel's annexation and settlement of Palestinian territory on that basis. Examples of those resolutions are also listed in Guyana's written statement. Those resolutions represent a clear recognition by the Security Council that Israel has annexed most of the occupied territory in contravention of fundamental principles of international law, and that it intends to exert perpetual control over that territory. Third, successive Secretaries-General of the United Nations have also repeatedly described and condemned Israel's annexation of Palestinian territory in official published reports. In 2010, for instance, the Secretary-General referred to Israel's annexation of East Jerusalem, which is a flagrant violation of international law. In 2015, the Secretary-General reported to the General Assembly that, quote, in the West Bank, the establishment and maintenance of the settlements amount to a slow but steady annexation of the occupied Palestinian territory. Similar statements are once again cited in Guyana's written statement. Fourth, the UN's Independent International Commission of Inquiry has also concluded that Israel has illegally annexed much of the West Bank and intends the occupation to be permanent. In its September 2022 report, the Independent Commission concluded that, quote, Israel treats the occupation as a permanent fixture and has, for all intents and purposes, annexed parts of the West Bank. The report went on to describe Israel's settlement enterprise as the principal means used by Israel to create irreversible facts on the ground to support its permanent occupation. The Commission added that statements made by Israeli officials provide further evidence that Israel intends the occupation to be permanent. Fifth, successive UN special rapporteurs have similarly concluded that Israel has annexed the occupied territory. In 2021, for instance, the special rapporteur reported that Israel's occupation has become indistinguishable from annexation. He highlighted the de jure annexation plans made by Israel, and he cited the plentiful evidence that Israeli policies and practices are designed to pursue a strategy of de facto annexation and permanent control over the Palestinian territory. In a report published the following year, the Special Rapporteur observed that the implantation of hundreds of thousands of settlers in the occupied territory was intended to, I quote, demographically engineer an unlawful sovereignty claim through the annexation of the occupied territory. He concluded that Israel's occupation had burst through the restraints of temporariness long ago, and that Israel has progressively engaged in the de jure and de facto annexation of occupied territory. Mr. President, Israel's annexation of Palestinian territory and its clear intention for the occupation to be permanent render the occupation unlawful as a whole. This has already been recognised by the United Nations. In 2022, the Independent Commission of Inquiry concluded that, and I quote, there are reasonable grounds to believe that the Israeli occupation of Palestinian territory is now unlawful under international law, owing to its permanence and to actions undertaken by Israel to annex parts of the land de facto and de jure. In January this year, the Secretary-General, citing international law and the resolutions of the Security Council and General Assembly, concluded bluntly that, quote, Israel's occupation must end. When the United States read aloud from the Secretary-General's statement earlier today, it regrettably excised these crucial words. However, the State of Palestine read them to you on Monday. As the State of Palestine pointed out, the Secretary-General stated 1 month ago that, quote, Palestinians must see their legitimate aspirations for a fully independent, viable and sovereign state realised in line with United Nations resolutions, international law and previous agreements. Israel's occupation must end. Guyana emphatically agrees, both with the Independent Commission of Inquiry and the Secretary-General. The occupation is unlawful. The occupation must therefore end immediately, comprehensively, irreversibly. Mr. President, this court needs no reminding of the importance of international law or of the grave consequences which ensue when it is systematically disregarded. The court also needs no reminding of the profound contributions that its past advisory opinions have made to the plight of peoples and states afflicted by the scourge of colonisation. For many, many years, Israel has chosen to place its own expansionist interests above the duty to respect international law, including Jus Cogens norms and the UN Charter. The result of that deliberate defiance of international law has been decades of dispossession, oppression and injustice for the state of Palestine and the Palestinian people, who have been systematically deprived of their fundamental right of self-determination. These advisory proceedings are a vital opportunity for the World Court to address and to begin to redress the immense harm wrought by Israel's unlawful occupation. With international law as its bedrock and justice as its guide, an advisory opinion from the Court will provide a lodestar for the United Nations and all of its member states to chart a course which reverses that dispossession, which relieves that oppression, and which remedies that injustice. In Guyana's submission, it is only through the rule of international law that a permanent and peaceful resolution of this decades-long conflict may be achieved. An authoritative exposition of international law, including a determination by the Court that the occupation is illegal as a whole and must be brought to an immediate end, will serve the ends of justice, will vindicate the rule of international law, and will provide the basis for a just, comprehensive and lasting peace. Mr. President, members of the Court, I thank you very much for your kind attention.
I thank the delegation of Guyana for its presentation. I invite the next participating delegation, Hungary, to address the Court and call upon Mr. Attila Hideg to take the floor. You have the floor, sir.
Mr. President, distinguished members of the Court, it's an honor to appear before you today on behalf of Hungary concerning the case legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. We take this opportunity to reaffirm the importance that Hungary attaches to the respect for international law and the role played by the principal judicial organ of the United Nations. The government of Hungary recognizes the significance of this case and the potential impact it has on the prospects for peace and stability in the Middle East and beyond. In discussing the Israeli-Palestinian conflict, one must reflect on the broader political context. Hungary recalls that in 2004, this esteemed court clearly stated in its advisory opinion concerning the construction of a wall case that the resolution of the Israeli-Palestinian conflict can only be achieved through direct negotiation between the parties, on the basis of the international law and through the implementation of relevant Security Council resolutions. Since 2004, this fundamental approach has not changed, although numerous aspects of the political context have shifted. As Hamas came to power in 2007, it rejected fundamental pillars of the existing political framework, in particular the Quartet principles, including Israel's right to exist, as well as renouncing violence as means of achieving goals and adherence to previous agreements between the parties. This has significantly affected the existing peace initiatives and has induced intra-Palestinian divisions that have proven difficult to resolve over the years. We must also note more recent developments that have yielded significant change in the broader political dynamics of the conflict. The Abraham Accords, established in 2020, provided a novel approach that has allowed
for the normalization of relations between Israel and a number of Arab countries. We believe that, in a political sense, the Abraham Accords represented an effort to create a more conducive environment for the negotiated settlement of the conflict. Moreover, it aimed to provide a solid foundation for enhancing regional peace, prosperity and stability. Unfortunately, the progress of these promising developments were impaired by the horrendous terrorist attacks conducted against Israel by Hamas on 7th of October 2023. What happened on 7th October was one of the worst terrorist attacks and sexual barbarism the world has seen in 100 years. On that Saturday morning, innocent Israeli civilians were awakened by an unprecedented brutal terrorist attack, the launching of thousands of rockets, the torturing and killing of hundreds, among them babies, and Hamas taking more than 200 hostages. Hungary strongly condemns these horror terrorist attacks and calls for the immediate and unconditional release of all hostages. These actions are not just an attack on a democratic country, they represent an assault on all democracies around the world. These actions are not just a clear violation of international law, they are also crimes against humanity. Israel has since been fighting the terrorist organization Hamas with the aim to eradicate terrorists and to prevent such horrific terrorist attacks ever happening again. The evil of terrorists is well shown by the fact that they use innocent civilians, education and healthcare facilities as shields. Sparing the life of both Israeli and Palestinian civilians is of the utmost importance. Now, as well as in the future, in the interest of a sustainable peace free of terror. We welcome that the esteemed court has recently called for immediate and unconditional release of the hostages held by Hamas and underlined that all parties to the conflict must abide by international humanitarian law and international human rights law. Upholding the rules is non-negotiable. Nonetheless, we must also note that the proceedings brought before this esteemed court may directly contribute to the escalation of the conflict. We are of the view that both the present proceedings as well as the proceedings against the State of Israel on application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip may be considered as provocations in the ongoing conflict, not contributing to the de-escalation and an eventual settlement of the conflict. A potential utilization of the court in the communication war could create a never-dividing lines and could continue to fuel tensions in one of the most severe conflicts of recent history. Bearing in mind this aforementioned broader context, let me now turn to addressing three main issues that Hungary considers important to highlight. Members of the court, I thank you for your kind attention and would now kindly ask you, Mr. President, to call upon Mr. Kocsis to take the floor to continue with the remainder of the arguments of Hungary in this case.
I thank Mr. Hideg, and I now give the floor to Mr. Kocsis. You have the floor, sir.
Mr. President, it is my pleasure to continue the presentation of Hungary's considerations in the present advisory proceedings. Hungary duly submits that the United Nations General Assembly's request for an advisory opinion contained in Resolution 77/247 of 2022 satisfies the conditions set out in Article 65 of the Statute of the Court and in Article 96 of the United Nations Charter, both regarding the competence of the requesting organ and the substance of the request. Accordingly, the Court has jurisdiction in this case. However, we also duly submit that based on Article 96 of the United Nations Charter, it is at the discretion of this Court to decide whether it exercises its jurisdiction. We put to the Court that there are compelling reasons to deny the request for an advisory opinion. All these reasons pertain to the issue of judicial propriety. The reasons include the specifics of the questions, the essentially bilateral nature of the dispute and the lack of consent of one of the parties, as well as the already existing legal framework for the resolution of pending issues and disputes between the parties. Consequently, the Hungarian government is of the view that the Court should decline to exercise its jurisdiction. Mr. President, we now turn to the second issue, the compelling reasons why the Court should reject to give an opinion on the request made by the General Assembly. We recall the existing precedent for rejecting a request for an advisory opinion based on compelling reasons. The predecessor of the Court, the Permanent Court of International Justice, declined to issue an advisory opinion on the status of Eastern Karelia. This decision has never been overruled. We note that the Court, in its subsequent decisions, has always taken due care to demonstrate the factual differences from the Eastern Karelia case when considering the exercise of its jurisdiction. This must lead us to the conclusion that the legal criteria set out in that decision remain authoritative. As to compelling reasons, we would like to bring the Court's kind attention to the following three considerations that individually, as well as cumulatively, may compel the Court to refrain from issuing an advisory opinion to the present questions. First, we express sincere doubt that the nature of the question would allow for an appropriate advisory opinion. While the title of the General Assembly Resolution 77/247 speaks of Israeli practices affecting the human rights of the Palestinian people, the question posed in operative paragraph 18 of the resolution says, legal consequences arising from the ongoing violation by Israel of the right of the Palestinian people to self-determination and related discriminatory legislation and measures. The questions encompass a wide range of subject matters, touching upon the legal status of the occupied Palestinian territories, the unspecified Israeli practices, and the legal consequences of both the status of the occupied Palestinian territories as well as those practices. While the questions do not specify the actual practices and legislation, they already provide a distinct qualification stating their illegality and unlawful nature. Replying to these questions would inherently entail an affirmation of the statements incorporated in the question. Advisory proceedings were designed as an instrument to contribute to and facilitate the work of the requesting organs. These proceedings are not an appropriate forum for making the kinds of determinations that are implied in the question. As the Court put it in the Kosovo advisory opinion, Article 65 of the Statute of the Court has not created a form of judicial recourse for states. In our view, should the Court decide to reply to these questions in the form of an advisory opinion, that would be tantamount to adjudication on the very subject matter of the underlying concrete bilateral dispute that undoubtedly exists between Israel and Palestine. This leads us to our second consideration, concerning the essentially bilateral nature of the dispute. At the outset, we duly take note of the Wall advisory opinion, in which the court concluded that the conflict between Israeli and Palestinian parties is located in a much broader frame of reference than a bilateral dispute. However, it must be pointed out that this broader frame of reference has fundamentally changed due to the shifting political dynamics within the conflict. The Wall advisory opinion was issued during ongoing peace negotiations between the parties that, alas, have not yielded the desired outcome. Unfortunately, in recent years, despite repeated calls for relaunching good faith negotiations between the parties by the international community, including this very court, the process has stalled. Deadlock continues to ensue, and the conflict thus remains an acute bilateral dispute between the parties. On this basis, we argue that providing an advisory opinion would inevitably raise the question of circumventing consent of Israel as party to this bilateral dispute. We refer to the fact that Israel voted against Resolution 77/247 in the General Assembly in 2022. Israel's attitude in the previous decades has demonstrated its readiness to participate in different negotiations and peace processes. This is the very way the esteemed court itself suggested solving this dispute. For these reasons, we recall our request for the court to exercise its right to decline rendering an advisory opinion. As for our third and final query, we refer to the already existing and accepted institutional architecture for maintaining international peace and security. In this institutional fabric, each actor has its own distinct role and responsibilities as institutional guarantors of peace and security. With this system, it is the United Nations Security Council that has the primary responsibility for the maintenance of international peace and security according to the United Nations Charter. Should the court decide to render an advisory opinion on this matter, this would, in our opinion, inevitably result in the unduly politicization of the esteemed institution of an otherwise strictly judicial character. This could threaten to undermine its ability to contribute to the maintenance of global peace and security. Additionally, such an opinion, irrespective of its content, would inevitably become part of an already heated political debate, particularly in the aftermath of the barbaric Hamas terrorist attacks conducted on 7 October 2023. Furthermore, when discussing the institutional backdrop to this conflict, it must be pointed out that there is, in fact, an established framework for negotiations aimed at the political settlement of the conflict, emanating from the various United Nations Security Council resolutions, such as 242 and 338. Moreover, to this day, this established negotiation framework, built around the Oslo Accords, remains the recognized framework by both parties to the conflict. It is crucial to also mention the involvement of other international mechanisms and actors in the resolution of the Israeli-Palestinian conflict, including the United Nations Special Coordinator for the Middle East Peace Process, UNSCO. The role of the Special Coordinator is important in facilitating dialogue and negotiations, promoting peace, and coordinating international efforts towards a just, lasting, and comprehensive resolution. Therefore, one must come to the conclusion that if we are to stay true to this very court's ruling issued in the Wall Advisory Opinion, what is needed today is not a new legal interpretation, but a renewed effort to restart peace negotiations, implementing in good faith all relevant existing United Nations Security Council resolutions. In conclusion, we reiterate there is no alternative to the political resolution of the conflict. A political resolution that is based on direct negotiations between the parties, which allows the State of Israel to live side by side in peace, security, and mutual recognition with an independent, democratic, contiguous, sovereign, and viable state of Palestine, with Jerusalem as the future capital of both states. Therefore, Hungary respectfully requests the Court to decline providing an advisory opinion. Mr. President, members of the Court, this concludes our presentation today. I thank you for your kind attention.
I thank the delegation of Hungary for its presentation, which brings to a close this afternoon's hearing. The Court will meet again tomorrow morning at 10 a.m. to hear China, Iran, Iraq, Ireland, Japan, and Jordan. The sitting is adjourned.